from the underlying panel.
Okay. Yeah. Thank you, Mr. Minner. Appellant was convicted of several counts of endangering the welfare of children and sexual abuse. In explaining its upward deviation from the sentencing guidelines when imposing Aplt sentence, the trial court noted that it took into account the fact that while it was appellant's first conviction, he had, quote, previous other contacts, unquote, with police which did not result in convictions. These are referred to as, quote, unquote, bear arrests. We granted review to consider whether the trial court's consideration of appellant's bear arrest record when imposing his sentence violated the sentencing code and appellant's due process rights, and further, whether the Superior Court applied the correct standard in reviewing appellant's claim. You may proceed.
Thank you. May it please the Court, Leonard Sosnov for Mr. Burry. The issue here is whether the fact that police decided to arrest a defendant in the past is a factor that may be considered in deciding on an appropriate sentence. And this is not an issue of first impression for this Court. The answer is clearly no. And it's been decided by this Court in sentencing contexts, other contexts, by every federal court of appeals. You cannot consider adversely the fact that somebody was arrested.
Because an arrest means nothing.
Correct. It means nothing.
It's an accusation.
It's just an accusation.
Just an accusation, and this Court has said over and over again. The first time was in 1957 in the Jones case, where this Court said it was irrelevant to bring up the defendant's past arrest. That was a jury sentencing case. Again, in Commonwealth versus Cottle, years later, in a probation revocation case, this Court said it was error for the Court to consider adversely 3 prior arrests.
What do you mean by, in your reply brief, when you write, regardless of whether a defendant has been arrested, the Commonwealth always has the opportunity to present evidence at sentencing to try to establish prior unlawful activity by a preponderance of reliable evidence. So by that, do you mean only convictions? Is that what you're saying?
No. What I'm saying is convictions, we know, shows prior criminal conduct proven beyond a reasonable doubt. But the United States Supreme Court has held, and we're not challenging this, and it's really not just what the United States Supreme Court says, it's been the law forever, basically, that when you consider the character of the defendant, you're not limited to convictions. So the fact of an arrest is actually irrelevant to the whole analysis. If you're going to say that this is a factor that a judge can consider, you have to, by reliable evidence, prove the past criminal conduct. When you prove it by reliable evidence, past criminal conduct, regardless of whether there was an arrest, now you have proven something about the defendant's character.
So is there a Venn diagram problem there? I'm just trying to ascertain your position is that prior arrests cannot be used to enhance a sentence, but prior unlawful activity can, even when there's not been a conviction. So how are you going to, how's the Commonwealth going to establish this unlawful activity? It's not allowed, in your view, to bring in prior arrests, but there's something else other than convictions. What is that body of evidence?
So I'd say, first of all, the Court does not have to decide that issue because it's not involved in this case. It's just bare arrests, and the judge only considered bare arrests.
It's contextual. I mean, if we're going to look at whether bare arrests can be referenced,
no, I'm not avoiding the question. I'm ready.
I'm glad you brought up bare arrest, because when you repeatedly talk about bare arrests, then there's like what, arrest plus, like arrests that are not bare arrest, but arrests that
result in conviction. Right.
Well, no, we all know that. More than but there's there seems by implication to be some middle ground there. There's bare arrests over here, which you say, no, we can't have those. There's convictions, we know we can use those. But are there like arrests with meat on the bones here? What are you getting at?
Okay, so what I'm getting at, we have an easy reference point for this, and that's revocation hearings, probation and parole. And ever since 1973, in the Daisy Cates hearing, this court held that a judge does not have to wait for the outcome of the criminal justice system to see whether there's a conviction or not. A judge can go ahead with a revocation hearing, and based on non-hearsay evidence, the judge could go ahead with a hearing, and if the criminal conduct is established by a preponderance of the evidence, the judge can revoke probation. And even if the charges were later withdrawn, judge could, after that, have a hearing. When there's a resolution by an acquittal, no. This court held out in Commonwealth versus Brown a very long time ago. But we have the revocation context where if you're going to have consequences on a defendant, like revocation, possible loss of liberty, and here, sentencing, possible additional loss of liberty. Obviously, Mr. Burry deserves some loss of liberty. Question is, you have to have constitutional procedures if there's going to be potentially additional loss of liberty. So we have the context already. Commonwealth versus Royster.
Is it ironic, counsel, that like you could have a fact pattern where some guy engages in unlawful conduct, gets arrested, but the charge is null prost, or there's an acquittal, or what have you. But you can bring in all sorts of circumstances in that sentencing to enhance up to the arrest. You're saying you don't mention that arrest, but mention everything that undergirded the Commonwealth's decision to make the arrest.
Or are you saying
or not make the arrest? Because the issue is very simply is, and this happens in probation and parole revocation hearings all the time. Somebody may not have been arrested, but there is a claim by the state parole board, for example, that you violated parole by assaulting somebody, even though you were never arrested. So that
you could have been arrested and not charged. The DA could have declined charging.
Arrested. The parole board is aware of it because from the parole agent has talked to
okay, I understood this better before you began your argument. I am confused. I am confused now because I would like to focus on the sentencing and the relevance to an arrest, a bare arrest, in a judge's sentencing decision.
That's the easy one, because the prosecution concedes it in light of all the cases that have gone before this court before. As I said, 1957 in Jones, Cottle, court said 3 prior arrests considered by the revocation judge should not have considered adversely. Commonwealth versus Scott, a case involving character testimony presented by a defendant. And this court held in Commonwealth versus Scott, you can't cross-examine about arrests because they don't reflect on his character. A person can be innocent or guilty. An arrest is, one of the main reasons to really put it in focus is an arrest is not even conduct by the defendant. You can't call it reflecting on the bad character. A person who is arrested is the arrestee. It is conduct by the officer. So the officer is either properly or improperly made an arrest.
Pardon me if I might. Aside from the semantics, you appear to be arguing that this court adopt generally the parameters that the federal sentencing guidelines set out and federal courts follow in terms of what prior similar adult criminal conduct not resulting in criminal convictions can be used at sentencing. Am I correct? The Commonwealth argues it extensively. How is it different?
Well, it's different once you get beyond bare arrest.
No, it cannot. As I understand the federal case law, for the most part, and I'm focusing particularly on the Third Circuit, a bare arrest is not going to get you there.
Right.
What you need is additional proof of the prior similar adult criminal conduct.
And why this becomes a more complex issue, though I think there's I would urge a simple answer, is that the standard is reliable evidence. So a court has to decide what is reliable evidence. Prosecution contends if an accusation is made in a pre-sentence report, that's good enough evidence.
Wait, can I just stop you for a minute? Do you
Yeah.
agree with me that what you're suggesting is that we follow what some, if not most, of the federal circuits follow in terms of the sentencing guidelines and the use of prior uncharged criminal adult conduct?
Not exactly, and because I haven't fully briefed, because the courts don't all say what are the parameters of how you have reliable evidence. What is the reliable evidence? The federal courts don't all agree on it as far as what is reliable evidence.
So why aren't you arguing that we cannot have our sentencing judges consider any prior similar adult criminal conduct not resulting in criminal conviction?
I think the court certainly could decide that, rather than get into it's a messier issue.
I'm asking you, why aren't you arguing that? I mean,
should be arguing.
It is a messier.
Obviously, I should be arguing it.
The reason the federal courts do it, is because Congress told them to do it.
I know, and in fact, one reason I should have made this argument is exactly because this court went beyond Scott, for example, with impeaching a character witness. In Scott, the court said you cannot try to impeach a character witness with a prior arrest. They said it has to be something much more like a conviction, and even the conviction sometimes is questionable. So, yes, even though I have said that, I think certainly a clearer rule would be simply, if it's not a conviction, judges should not consider it as sentencing.
Well, counsel, the way the question is phrased that we took was all we had to decide was bare arrest.
Yes.
And I think you seem to be suggesting that everybody sort of agrees that bare arrest, no matter in what context of sentencing, is unconstitutional, is you can't do that.
Yes, and it's a violation of Pennsylvania law.
So we basically took this for error review.
And
The harmless error issue. There's the harmless error question.
well, there's a question in between, if I can, unless there are more questions about.
Well, I do have a question. Should I be at all concerned, putting aside the bare arrest side of things, should I at all be concerned that the trial court judge here, in explaining what was in her mind in sentencing, used the bare arrest record, or for that matter, even if it was more fulsome with evidence of it, to offset the zero score?
Well, that shows prejudice, even if we didn't have a per se remedy, which I
mean, is the zero score, in other words, maybe it could be used in a different case to talk about amenability of rehabilitation and things like that, but is the zero score, she seemed to tie it to the zero score. She basically said, it says zero, but I don't believe it.
I don't think it can be considered for amenability to rehabilitation because an arrest reflects nothing about a defendant, which has been said over and over, which has been stated over and over again by this court and the federal courts. It has no relevance to whether a defendant's amenable to treatment, that a police officer may have arrested the defendant before, once, twice, or whatever. And when we talk about fundamental fairness, it's not only a lack of conduct by the defendant. We do know, and I didn't brief this extensively, and the amicus brief discussed it, we do know that statistically, there are plenty of statistical studies that people of color and people from lower socioeconomic neighborhoods are arrested disproportionately. So when you think of fundamental fairness and whether you're going to consider arrests against the defendant as character or amenability to treatment,
We don't even need to get there, though, do we? We don't even need to get there, because I think we all understand that a bare arrest does not have any meaning. The fact of the bare arrest does not have any meaning in a sentencing context.
I keep thinking of the bare necessities. Remember that? Suppose.
I don't like the word bare, by the way. I didn't frame that question before I got in the case. Suppose bare arrest. Suppose there's error. Okay.
can you imagine circumstances in which the error would be harmless, and if so, wouldn't that necessitate a harmless error analysis? Let me hypothesize a case where the judge, let's say we said no bear arrest. That's not, not good, not okay. Now, but it happens, and the judge says, well, there was a bear arrest put in, but there's all these factors that lead me to this sentence, and all sorts of stuff that lead, to aggravation of the sentence. You could imagine such a hypothetical, and I assume, to the extent you can imagine that, would that militate for harmless error analysis? Because if you can imagine that hypothetical, how can it be structural error? So
I think, and there are a lot of problems with the Superior Court's analysis in these cases. First of all, the point that everybody agrees on, the Superior Court has ruled over and over again, you can consider arrest. So that
we don't really care that much about what they've done. We're trying to decide what the rules are.
Okay. So what the rules mean, when we talk about remedy, the Superior Court talks about, we view this as an abuse of discretion standard. It can't be an abuse of discretion standard. This is a legal error. And the Superior Court, over and over again, refers to the issue as being one of abuse of discretion. It's not a substantive problem. A challenge to the sentence is overall unreasonable. And there we weigh everything. So as you put your finger on it, Justice Wecht, the real issue, which has been ignored by the Superior Court, the relief either has to be per se reversal, or you have to apply the harmless error standard, not what the Superior Court has been doing. And I would urge that it should be a per se. And the reason it should be a per se is because this is a constitutional violation, first of all, not just state law. This is a violation of due process. So I don't think that should be totally determinative if I have a moment to discuss that. But this is a constitutional error, and when a judge is considering this, it is almost impossible to say exactly what effect, and the federal courts have talked about this, what effect it had on the judge with the ultimate sentence. And therefore, since it's almost impossible, and we're not going to have 20 factors, cases like this typical case can be a few factors. So as far as what weight it had, potentially, in the analysis, this constitutional violation, this is not a novel idea as far as per se. The Bethea case, lead sentencing case of this court, where the judge said at sentencing, I'm taking into account the fact that you decided to go to trial and have a jury trial. And this court held that that was reversible error, not harmless error analysis, because we don't know exactly what role it played in the judge's decision. And I would suggest this court's very recent decision in Taylor, which, at the end of January, which cited Bethea many times.
Counsel, I have a question, and maybe you can help clarify this. We understand that the General Assembly created the sentencing guidelines, and in the statute required the Pennsylvania Commission on Sentencing to actually come up with numbers. So in its quest to consider an offense gravity score or a prior record score, hypothetically speaking, did the sentencing guidelines take into consideration arrests such that this would be a duplication, if not a violation, due process if we considered? I'm not aware of that answer. Do you have an answer to that?
Oh, the answer is, in the prior record score, is convictions only. And the enabling statute for the commission was convictions only, which I think shows an awareness of the due process restrictions on what can be considered as sentencing.
So are we to glean that the General Assembly, by creating the sentencing guidelines, wants the court not to consider a blanketed arrest? It's only considering convictions as part of the offense gravity score.
Absolutely.
Or prior record
That's
score,
why
I
even the
should say.
judge in this case recognized, she says, I know it's a 0 under the prior record score, but I don't think it really should be a 0. So whether the judge...
Our General Assembly has done exactly the opposite of what Congress did.
Pardon?
Our General Assembly has done exactly the opposite of what the federal Congress did when it allowed the consideration of prior similar adult criminal conduct not resulting in convictions. Congress said...
Not arrests,
though.
Not arrests.
Well,
Right.
But that's what prior... Correct. But so you would say that if our legislator wanted that to be considered, they would have said that?
I think, yes, that would be a relevant consideration, the fact that we did not, that there is no provision like in federal law that you should consider all this, that the whole relevant conduct provision, which is in federal law, which is not here. So certainly that's a reason for saying that only convictions as reflected by the statute and reflected by this Court's case law. Getting back to remedy, the Taylor case, which was just decided January 29th. And the issue was the juvenile and transferring the juvenile to adult court. The judge said, well, you didn't really testify and admit that you were involved in this. That's one of the reasons I'm transferring it. And this Court held it was a per se or structural violation, that because it is a kind of serious violation, and this is a constitutional violation, just as...
Let me ask you, let me tease that out, Mr. Sosnoff. So that's, obviously a Fifth Amendment flavor issue. That's a big issue there, right? So, but here in this case, suppose we hypothesized a judge at sentencing considering a prior arrest and then 10 prior convictions. Why would that not be subject to harmless error analysis? Can you not envision a court saying, well, that's true, the judge did have evidence at sentencing of a prior arrest, but the judge also had evidence of 10 prior convictions, and we're going to deem the error harmless. Isn't that a different hypothetical than Taylor?
I don't think so, because Taylor, the judge could have 10 other factors. Bethea, the judge could have 10 other factors. You can't have a constitutional violation factor and then say an appellate court, and I'll just quote now from footnote 36 of the Taylor decision, basically, a judicial parsing of a cold record to find other evidence in support is not a suitable manner for correcting an error of this nature. So it's not something the appellate court, as this Court said in Taylor, should get into. And I want to say one other thing about harmless error as opposed to per se. When we're talking about sentencing determinations, it's a lot different overturning a criminal conviction because you decide that there was an error. It can have, as this Court has mentioned many times in discussing harm, it can have great consequences for the Commonwealth. They have to retry the case, prove it beyond a reasonable doubt. Memories may have dimmed. Witnesses may be unavailable. When you reverse a sentencing determination because you're not sure whether it had any real impact on the, we know in this case it had a real impact by the judge's comments, but if the judge didn't add about the sentencing guidelines, we know that it had some potential, and Bethea discusses this, some potential effect on the ultimate sentence. When you reverse the sentence, it goes back to the trial judge. There is no proof beyond reasonable doubt by the prosecutor. There are usually most sentencing cases, there are no, at the sentencing hearing, factual determinations. There's no burden for the Commonwealth. When it goes back, the judge can give the exact same sentence. And former Chief Justice Saylor made the same point when this Court invalidated the mandatory minimums in Hopkins and Wolf.
Courts have often done that. I mean, think of the Dodge cases. On Superior Court, we reversed trial court, I think 3 times, and the same sentence came back, and eventually the court said, okay. So that can happen. You're right about that. Okay, I'm sorry.
There's a follow-up to that.
He made the point. He said, former Chief Justice Saylor said, we're not creating a windfall for the defendant. He just has to be sentenced according to law with no improper illegal factor like a mandatory minimum sentence. The judge can give the same sentence. If the judge justifies it in the record and the judge has discretion the discretion in sentencing is balancing all legitimate factors. So the judge on remand has the discretion to balance all legitimate factors and maybe come to exactly the same conclusion, maybe not. The defendant is entitled to a sentencing proceeding that is not infected and polluted by a violation of procedural due process rights or some other violation of constitutional rights.
My question is, with regard to the sentencing arena, from my experience on the Superior Court, when we are reviewing what a sentencing judge looked at, we are always, it's not maybe the golden standard, but it was always a standard if the trial court was looking at a pre-sentencing investigative report in the course of their sentencing. And if you look at Mr. Berry's PSI here, it clearly shows the arrest. So is there some tension with some of the prior case law vis-a-vis sentencing in conjunction with your argument today?
I think that the way I'll answer this might be a little indirect, but the Rule 702A3, the Rules of Criminal Procedure, says a pre-sentence report shall contain information about the circumstances of the offense and the character of the defendant. So since arrests don't reflect on the character of the defendant and it can't be considered sentencing, this court, either by interpreting the rule, tells pre-sentence investigators don't include it in the pre-sentence report anymore, or by interpreting the rule. So that's one thing. But because traditionally pre-sentence reports have contained a lot of information, some which a court cannot rely on. We trust the judges not to rely on it. So the fact that a judge knows about it, let's say we continue with most pre-sentence reports discuss arrests. They at least note them. He's been arrested 3 times. If pre-sentence reports are going to continue, I would hope that this will be eliminated, but let's say it's continued. Knowledge is not the same thing as using it against somebody.
Okay,
and Bethea is a good example. I'll just give one example. In Bethea, the judge knows that the defendant chose a jury trial and a right to trial. The judge has knowledge of that. The judge can't use it as a factor, though, adversely against the defendant. And it's the same thing if we don't change the practice of pre-sentence reports. A judge can know about prior arrests, but we trust that a judge is not going to consider it adversely against the defendant, particularly when this court says once again that you can't consider it against the defendant.
I thought that your start of your argument today, you were on a track where you were going to argue that some prior arrests, if they can be shown to be accurate information and knowledge with regard to the facts of the prior arrest were put on the record, may be considered. And then you kind of veered off that course to now it's a per se constitutional violation. And so my question is, particularly in this type of cases where we understand across the board there's many child and victim sexual crimes that occur that may be reported, but for many reasons not prosecuted, for many variety of reasons, and including the reason that perhaps the person's not guilty, but also including the reasons that they may be guilty, but maybe the witnesses aren't going to come to testify. So when you have a case in this arena, and maybe it happens in the arena of domestic abuse cases also, If you are seeing where the person has prior arrests in the area of 20, 30, 40 arrests, or 5 or 6, is there some threshold where the trial court can consider it at all, or is it your position that nope, it's a per se rule, the trial judge cannot consider that?
So before I was talking about per se rule as far as remedy, but now we're talking about back to can a judge consider it, and the district attorney cites their arrests are worthless by themselves, and the First Circuit decided this. I would say that it should be treated just like math. 0 plus 0 plus 0 plus 0 must equal 0, because we cannot consider and speculate. That's why there's a due process violation. The defendant was in fact guilty. The First Circuit in a case, I'll just point out that adopting my approach, they had a case, which I've never seen a case like this before. The defendant had 44 prior arrests, not resulting in a conviction. And the court held it would be a violation of due process for us to consider that in deciding on the sentence.
Counsel, I don't disagree with you, but here's a concern that I have. What if the individual we're in front of the court with a sexual assault. There's been a prior history of 5 arrests for similar activity. What if the Commonwealth, knowing that for whatever reason, let's assume statute of limitations, witness out of the area, what if the Commonwealth subpoenaed all the victims of those cases to testify as to the bad character because it's the character trait at issue? Is that allowed in?
Do you mean it's sentencing?
Yes.
Whether they could subpoena the witnesses and there would be a hearing? That depends.
Because we're looking at arrest. I agree with you. Arrest doesn't equal
Right.
character. The question or concern I have by establishing this is that if the Commonwealth chooses to revisit those prior contacts and bring them in to testify under the character prong of the sentencing guideline, that's admissible. Would you have to agree?
I would have to say that if this court decides that only convictions can be introduced, then it cannot.
I thought you're not arguing that. I think Justice Doherty asked an interesting hypothetical.
Well, I changed my argument somewhat because
I told you.
because I thought the court was making good points. I mean, why
It's
should
because I told you it was a better argument.
if I go back?
That's an honest answer. That's an honest answer.
I began by quoting your reply. No, I'm not, messing with you here. In your reply brief, you cited prior unlawful conduct. So I think it's an interesting hypothetical. Would that not be, provided these witnesses were instructed, do not mention prior arrests, or that's going to blow this thing up and we're going to have to do it again. If they are instructed and follow the instruction not to mention prior arrests, wouldn't that fit within your concession in the reply brief that prior unlawful conduct is fair game?
Non-hearsay evidence. The witnesses come in who allege I was the victim or I saw this happen. If the witnesses come in, they're subject to full cross-examination, and the defense has the opportunity to be heard and present witnesses. That is the position that I took in my reply brief, which is like a Daisy Cates hearing. And I will say, as a practical matter, most judges won't do that.
The difference is a violation hearing based upon an arrest as opposed to a sentencing based upon a conviction. I disagree with you on the Daisy Cates issue. I agree with you that you shouldn't be able to introduce an arrest for a Daisy Cates violation.
Oh, no.
But you're allowed to bring, if the Commonwealth is diligent enough and you have victims who are willing to testify, that's sufficient under the current statutes. So its testimony can be used to aggravate the prior rep score, or whatever.
Not the prior score, but it does reflect on the person's character.
Correct.
So it has to be reliable, non-hearsay evidence with a full opportunity for the defendant to respond. If the Commonwealth thinks that there is a situation like that that's strong enough evidence for the Commonwealth.
We understand this. We actually do. Do you have anything you'd like to say to wrap up?
The last thing I want to say is one point that we haven't really explored, and that is the Superior Court's standard of review. Repeatedly, they hold that this error, and they've also held miscalculation of the guidelines, that all these errors are subject to abuse of discretion review. And there are very serious problems when there's a legal claim raised where the Superior Court judges things by abuse of discretion standard. First of all, we have a right to appeal this legal error. 9781A, Title 42, Article 5, Section 9. We have a right to appeal. When the Superior Court, for a legal error, says we view this as a discretionary issue, first of all, that means you have to have a 1925 statement, and they will find waiver if you don't include it there. Then, in their unlimited discretion, they could say it's not a substantial question for review. So if you raise the issue, we're not reviewing it on the merits. And then finally, they, in the end, can say, we've looked at everything, abuse of discretion, the judge did not act unreasonably. This is a de novo issue. The prosecutor doesn't dispute when I put in the standard of review for this court that the issue is subject to de novo review because there's a legal constitutional error that we are, it doesn't have to be a constitutional error, it's a legal error that we are raising. It's a de novo standard. So the review process can't be, we just see whether the judge, looking at all the evidence in the case, abused discretion or not. It has to be a de novo standard of review.
Of course, if they deem it to be a discretionary aspect of sentence, then if they deem it to be a discretionary aspect of sentencing, this court can't get to review what they do because we don't look at the discretionary aspects of sentencing.
And that's one of the reasons this case is important,
Sure.
to tell the Superior Court to stop labeling things. And they did the same thing, contrary to the United States Supreme Court's approach. They've done the same thing with miscalculation of sentencing guidelines. A court has no discretion to miscalculate the sentencing guidelines, either on purpose or unintentionally.
We understand this.
And I'll just say the last thing. I mean, Black's Law Dictionary, I think, sums up the situation pretty well when they say discretionary acts are those where there are no hard and fast rules. And there's a hard and fast rule at stake here. There's a hard and fast rule when they miscalculate the guidelines.
Thank you, Mr.
Thank you.
Sosnoff. Mr. Greer?
Good morning, Your Honors. May it please the Court. Andrew Greer on behalf of the Commonwealth. First, I'd like to start off by saying the question defendant presents is a hypothetical scenario that doesn't go to what happened here. This was not a bare arrest record. It was supported by evidence, and namely, I want to mention, just because this wasn't in my brief, in the mental health report of defendant's self-reported information, he said, when asked about 3 stab wounds he had, he said, my girlfriend, she don't like when I put hands on her, and was describing a situation that happened 3 years earlier when he was charged, as the arrest record showed, for domestic violence. He also said that he had been using marijuana daily since approximately ages 13 or 14, which corroborated the arrest record for the marijuana possession.
That all comes in if it is a harmless error analysis, but if it is structural error, then you'd agree that the reference to the arrest is impermissible, wouldn't you? Otherwise, you're arguing for us to reverse Jones?
I think it's only a structural error if it is entirely unsubstantiated and then relied on as a sense. I don't think the fact that an arrest happened before a judge and not a jury, like in a lot of the defense case examples, means that evidence can be excluded.
But aren't you?
It's never been proven beyond a reasonable doubt, but we're going to give it some weight because he was accused of it, so it's got to mean something. Isn't that inconsistent with Jones?
As you framed it, yes, but this is not about the accusation. Here with my specific example, it's defendant's own admissions to that conduct.
So it's not just a bare arrest.
Correct. Second of all, as the United States Supreme Court said in Williams about defining the difference about evidentiary burdens at trial versus sentencing, that there's both a historical basis and a sound practical reasons for those different standards, and that, I'm sorry, I'm quoting the wrong case. Much more recently, Watts, that the application of a preponderance standard at sentencing generally satisfies due process. So I think the clearest cut example of unquestionably being able to be considered an arrest that does not lead to conviction, but it led to the charges being held for court at a preliminary hearing already, has previously been established by a preponderance of the evidence. The facts of that case are then read into evidence at this sentencing, and that sentencing court cited the actual criminal conduct as an aggravating sentencing factor.
Never led to a conviction.
Correct.
Suppose you were wrongfully, I'm sorry, there's no jury here, so I can do this. Suppose you were wrongfully arrested, and then later you're being sentenced for something else. Would it not offend some principles that are fundamental to our law for the prosecutor to rise and argue, and for the jury, for the judge, sentencing judge, to consider the circumstances of your wrongful arrest, whatever other fat the Commonwealth put on the bones of that at the hearing?
I was going to say yes until that last part, because there's an addition of substantiating the arrest with something. I think that's where the difference is. I would agree that the mere fact of an arrest with zero more information, we know, yes, that is conduct of a police officer, and there could be illegitimate reasons or zero proof of criminal conduct.
Just one
but
more
that's
thing on that, and then I'll shut up here. So how much is enough? So we're required to articulate a standard, not just for Mr. Berry's case, but globally in Pennsylvania. So what's the standard by which we say, okay, a bare arrest is not okay, but if you add on this and you add on that, it's okay? I'm not discerning what that is.
I think it's sufficient simply to restate what the United States Supreme Court said and say it's preponderance. There is already well-developed law about all the different ways in which a preponderance of the evidence standard can be met. So I think, for example, the strongest and easiest example would be where an arrest led to charges that were held for court beyond a preponderance of the evidence at a preliminary hearing and withdrawn for some other reason, like a Rule 600 violation that has nothing to do with the facts of the case. As well, you could hear—
You wouldn't know that, counsel. I mean, it could fall apart because the evidence that was used at the preliminary hearing turned out to be fraudulent or forged or something of that nature. I mean, you have to speculate at that juncture as to why the charges were dropped. I mean, it's sort of the circumstances that the Third Circuit discussed in their Berry case, different Berry, which cautioned against speculating as to what the occurrences were surrounding the uncharged conduct or the charged conduct that didn't end in conviction. I mean, you'd agree with me. I mean, the Third Circuit went to great lengths to discuss this particular issue in terms of the federal sentencing guidelines. And, I mean, to say that they didn't embrace this entire notion of using arrests even with additional evidence is problematic. It's a question of what's enough. What's enough? I mean, doesn't it really — I mean, you mentioned Watts, for example, which is a fascinating case, but, I mean, the defendant in that case was found not guilty of a drug charge by a jury, but then that drug charge was used in sentencing. The Supreme Court said that's okay because the trial judge heard days' worth of evidence surrounding that charges, and although it wasn't enough to meet the required burden for criminal guilty, it certainly was enough to meet the preponderance of the evidence. Well, I mean, an entire case presented by the prosecution and the defense would, I think everyone would agree, to suggest that somebody could find that's a preponderance of the evidence. But that's the outer extreme, and
Exactly.
It's just
I think because if everyone agrees that that is preponderance of the evidence, saying that judges should be able to exercise discretion is not saying that discretion is unfettered. It fits into the scenario. So you have, Your Honor's just given a scenario where we would all agree that that was established by a preponderance of the evidence. I don't believe that means it's the only way it can be established by a preponderance of the evidence. I would still stand by my prelim example, but I would also...
How does your prelim get you there? Because, as we all know, credibility is not an issue at the prelim. So it comes up for trial, and it turns out the Commonwealth's witnesses are all lacking in credibility in the bench trial or the jury trial so finds. So what comfort does that give the defendant here?
I guess in that scenario, then there would have been an acquittal in your hypothesis, that there would be a subsequent acquittal of the offense. But in general, I understand your issue. There could be issues with...
Or null pros, I should have allowed for that scenario too.
Yeah.
For whatever reason, it happens all the time. It's just the prelim was bound over, as it should be, because there's no credibility there. But it turns out the case goes away along the pipeline somewhere. But under your standard, the prelim validates it.
And you have to speculate as to why it didn't go forward, which is, truly what at least the Third Circuit and I think maybe the 7th and 11th argue the same point. Can't be allowed to speculate as to what happened to preclude an actual conviction or even a trial.
Then, consistent with the other rules of evidence, live testimony or even hearsay evidence can be admitted at the sentencing, and then in the judge's discretion can find whether, again, to be very clear, because that is not what happened here, finding that defendant engaged in that prior criminal conduct, and I, the sentencing judge, am using that as that finding of the committing of prior criminal conduct as a reason for deviating from the guidelines.
Let me ask you one other question about this case as you described it. One of the arrests was for possession of marijuana. Why would that have any relevancy to the case at issue here?
I don't think it did.
So, but it was an arrest that was considered. I mean, does it have to be relevant? Adult conduct relevant to similar to the conduct at issue in the case that he's being sentenced on, or is it just any old arrest?
I just want to clarify what Your Honor means by considered in that. Do you mean, the evidence presented? No, Your Honor, because the pre-sentence investigation report includes a ton of other evidence of similar character, a lot of which in many of these, run-of-the-mill discretionary sentencing claims defendants raise on direct appeal would like to cite the same contents for purposes of saying, you didn't give me proper consideration of my mitigation evidence, which this is not a unilateral burden. The Commonwealth has a right to appeal the discretionary aspects of a sentence where there was an alleged improper mitigating factor.
You're assuming it's a discretionary aspect as opposed to a legal challenge, legality challenge.
Yes. And I think that is unequivocally decided by the precedent here. A different Taylor case, but from this court 3 or 4 years ago, said it is a paradigmatic abuse of discretion for a court to base its judgment upon an erroneous view of the law. Conversely, this court has set out 4 broad categories of claims that go to legality of sentence, which all deal with the statutory authority to impose a particular sentence, which is not at issue here. This was a legal sentence. If this court were to hold...
Can I just probe that for a moment? Is that true if the factor that was considered was an unconstitutional factor?
Yes, this goes into whether something is a proper or improper sentencing factor, improper sentencing factors, the defense argument is wordplay. I agree that a sentencing court does not have discretion to consider something it does not have discretion to do. Defendant is using that to say, and therefore it must be legality of sentence, which is entirely inconsistent with the law. There's both the affirmative support that this would be a paradigmatic example of an abuse of discretion, and it is also an example that's entirely excluded from these four broad categories of types of challenges to the legality of a sentence.
Just ask it a little bit differently. It's not an error of law to consider a factor and the consideration of which violates the defendant's constitutional rights. You're saying that's an abuse of discretion. For him to be sentenced based upon the consideration of a factor that is violative of his constitutional rights.
Yes, that is an abuse of discretion.
Counsel, can I just, first of all, I'm still struck by the fact that two prosecutors have used the word paradigmatically twice today.
It's a quote, if that.
I know, I'm working on that. The question we presented, that we took, and maybe we shouldn't have taken it, if you're correct, is bare arrest record. That's the question that we took. Now, you started your argument, I thought, pretty strongly on the idea that this wasn't a bare arrest record. So I pulled up your brief real quickly to look where this kind of came out. And, you know, as I'm thinking bare arrest record, I'm thinking of a textually defendant was arrested for X on this date and this charge, arrested for Y on this date of this charge, and then nothing else. That's bare arrest record in my view. You seem to, though, rely on the PSI report because the PSI report has some additional detail about the arrests. Does the detail to bolster a bare arrest, can it just be in the PSI report itself? Or when we say beyond bare arrest, you actually need confrontation of witnesses at the sentencing hearing and an actual finding of probable cause? In other words, can you rely on the PSI report itself to go beyond bare arrest?
And that's what at the end of my brief I said here. It would have been better if it ended with attachments or at least like a bibliography of sources for that information.
There were no attachments to it.
Right.
Yeah.
So it cited the sources, and if we had those, again, if we had those, and the court here was saying, I find you committed that, the reason I'm deviating from the guidelines is because I find you committed that criminal conduct.
Or maybe they didn't have to say that. Maybe they could have just said, you know, maybe I'm not finding you committed that criminal conduct, but I'm finding you did this. And that goes to your character, and we didn't talk about it being criminal conduct. I'm just trying to get to the idea of bare arrest record. Do you need something beyond the PSI report to get past bare arrest record?
Yes, to the extent that the PSI report is simply, you know, like, I will agree you can't just go, oh, well, I put it in the PSI report, but I'm just retyping what was in the arrest report.
Right.
And what we have here is defendant freely admitting to the mental health evaluator that he put hands on his, like, of two of the three substantiated in some degree arrests here, admitted to those underlying facts. And I'd say that defendant's own corroboration of those facts would be enough to say he.
And there's evidence of that there's evidence of that.
Yeah, this is I don't know how to cite it in the record, but it's pages 2 and 3 of the mental health evaluation,
Which is in the record.
Correct.
And the trial judge had it.
Which the trial judge had, and by the way, was the one it was the first one to mention this mental health report at the beginning. I don't think the parties even had it, and so in addition to there being a presumption that the court considered this information, I think the court pretty clearly acknowledged that. As to how defendant's prior arrest record was considered here poses another important question. In context, the court was not saying, I found you committed these certain previous acts that could be considered criminal, and therefore I'm making this like a de facto deviation from, I'm creating this as a de facto addition to the prior record score or something. Defendant began his sentencing argument by emphasizing that the prior record score of 0, but the way it was phrased was defendant comes before this court with no record of any kind. Again, following established Superior Court precedent, the court acknowledged that that was not true, but first started with at least 3 case-specific reasons as to why the court was deviating from the guidelines, and then said, quote, while this is defendant's first conviction, there are previous other contexts. This is not the anomaly that a prior record score of 0 would foreshadow to me. So while not maybe a model of clarity, what we can see by looking at this prior arrest record is it led to him being on supervision for a consent decree for his juvenile arrest. And this can show, are you amenable to like a probationary sentence? And it goes to that.
I'm sorry, counsel, do you maintain that that kind of a showing could not be made without reference to an arrest?
Sorry, what kind of showing?
Are there no other ways in order for you to establish these facts and circumstances without having to cite an arrest?
You can, but I don't view the inclusion of the fact of an arrest before a sentencing judge somehow taints that evidence. I kind of think that's absurd, where we could say there were no prior arrests, but we can bring in live witness testimony about criminal conduct that, you know, didn't lead to an arrest. I think it's
an opportunity in that latter scenario, isn't there?
Yes, and if that's what Your Honor's concern with it was, but what I understood is that I don't think what I'm saying is I don't think the mere fact of an arrest needs to be censored from the record.
I don't think that, but it's a black box. So in that black box is this evidence of a prior arrest. How does the defendant have assurance that that wasn't a factor in aggravating?
Because there's a presumption that the judges can know to consider competent, reliable evidence and disregard irrelevant evidence. Is there a presumption then
that the judge knows it's a mere accusation? Is that the presumption?
Yes, I think judges are aware that an arrest is less than it.
If that's the presumption, why does it come in? If it's just an accusation, there's all sorts of things that I'm accused of, my colleagues are accused of, you might be accused of. Accusations fly all the time. What's the evidentiary value?
Then in that, admittedly bare arrest record, I would say it, has minimal evidentiary value, but it is equivalent to a lot of, in evidentiary value, to a lot of the evidence that defendants are putting forth and citing as mitigating factors, which...
on the other side of that pan, the other pan is a whole heap of potential for prejudicial effect, right?
A prejudicial effect where?
You're talking about probative value. The other side of that scale is the prejudicial effect, right, traditionally?
Oh, yes. And again, I just don't view judges in exercising their discretion, unless they say otherwise. Again, it would be different if I say, I see in that, like first page of the PSI report, it says 1 juvenile arrest, 5 adult arrests, nothing more. And the judge, because the judge does need to cite reasons for deviating from the guidelines, cites, yeah, I see this isn't your first arrest. You're a repeat offender despite what the prior record score says, and that is my reason for deviating from the guidelines. Then I would agree, but that's just not what happened here. I don't think it becomes a structural error for the fact of these arrests to be included among all this other evidence that is entered to paint a full picture of a defendant's background and history, in addition to character. So not even saying it impacts the character. Again, a lot of this evidence of similar characters, what the defense is going to want the trial judge to rely on as mitigating evidence. The Commonwealth has a right to appeal that. And again, there's a difference between citing circumstances around an arrest that did not lead to conviction for the purpose of saying, I am finding by a preponderance of the evidence that you committed that conduct, and that is a reason I'm deviating, or saying, you have previous contact with the criminal justice system, you've been under supervision, you understand the consequences for getting wrapped up in the criminal justice system, regardless of your guilt of those underlying offenses. Yet here, going into the crimes you've been found guilty of beyond a reasonable doubt here, you went into those acts knowing what the likely consequences of criminal conduct would be. The prior record score of 0 does not accurately reflect your background and history, and therefore that is one of the factors, and the last and least important in deviating from the guidelines.
All right, I think we've got it. Any final questions? Thank you both. Very well argued. We're going to take a lunch break. I had said for people to be back at 1:15, but we ran a little longer here. I'm not going to resume till 1:45. Good afternoon, everyone. Would you call the next case, Mr. Minner?
Alcatel-Lucent USA versus Commonwealth of Pennsylvania, representing Commonwealth, Mr. John Martin, representing Alcatel, Mr. Housel.
This case concerns the Pennsylvania net loss carryover provision for the 2014 tax year, which provided that Pennsylvania corporate taxpayers may deduct from their state income tax the greater of 25% of their Pennsylvania income, or $4 million. We must determine whether our 2017 decision in Nextel Communications, which held that a similar tax scheme violated the uniformity clause of the Pennsylvania Constitution, applies retroactively to this case. Additionally, assuming that Nextel applies retroactively, we must also determine the appropriate remedy, specifically whether Alcatel is entitled to a tax refund under the Due Process Clause of the 14th Amendment to the United States Constitution. Please proceed.
Madam Chief Justice, and may it please the Court, my name is Bart DeLone. I'm with the Office of Attorney General, and I'm here on behalf of the Commonwealth. In Nextel, this Court reversed the Commonwealth Court's decision allowing a retroactive refund.
Mr. DeLone, I'm sorry to interrupt you. Could you move the mic closer
Sure.
to you? Thank you.
Disallowing the Commonwealth Court retroactive refund to Nextel itself and applied Nextel prospectively in that case. In General Motors, because of a significant difference in the structure of the statute at issue, this Court applied that decision retroactively. Nextel and Alcatel are on all fours and structurally identical. The Commonwealth Court erred in not applying Nextel prospectively to this action. Due process does not call for a different result, and as a matter of fact, the United States Supreme Court in Smith, this Court in Dana Holding, and this Court in August Smith recognized a distinction between the prospectivity, retroactivity analysis and due process, and determined that the prospectivity analysis was a threshold determination, and that only if you were going to apply a decision retroactively, then you needed to address due process. If you reached the prospectivity analysis, just as this Court did in Nextel, then due process is not implicated. And Your Honor, Madam Chief Justice, I think you got it exactly right in the summary. You said if we decide it's retroactive, then we have to make some due process determinations. Well, what the Court did in Nextel was decide that it was to be applied prospectively, and they did that. This Court did that in its severability analysis. And the severability analysis in Nextel and Alcatel are structurally identical. There is literally no difference.
Mr. DeLone, can I, since you're talking, I mean, this case was teed up on this retroactivity issue, and I have kind of a basic question. Nextel dealt with the provision of the tax statute. It's strange because the tax code, this is a definitional section that we're talking about, dealt with the 2007 provision for net loss carryovers for 2007, right?
Yes.
We're not talking about that provision, right? We're talking about a different provision.
We're talking about a different provision.
So why are we talking about retroactivity? Why aren't we just talking about whether Nextel is precedential?
Well, I don't think we should be talking about retroactivity. The problem we have, Your Honor, is General Motors.
Right. And I guess I'm wondering, maybe we shouldn't have talked about retroactivity in General Motors. We just should have applied Nextel as precedent as opposed to whether engaging in its because you agree Nextel did not declare the entirety in all the sections of the net loss carryovers in total unconstitutional.
That's correct. And
it was regard to a specific provision.
Correct. And that's a key difference, Your Honor, because if this Court were to take the position that Nextel is precedent and you need not concern yourself with General Motors, there would be no one more thrilled than the Commonwealth of Pennsylvania. And what Nextel presented with was a dollar-based threshold deduction and a percentage-based threshold deduction. This court in Nextel declared the dollar-based threshold unconstitutional, but left the percentage base. What happened in General Motors is the only thing they had, the only thing this court had, was a dollar-based deduction, and they eliminated it entirely. What Alcatel presents is exactly the same thing as Nextel. They have a dollar-based deduction, which now we recognize it violates uniformity, but they still have this percentage-based deduction, just like Nextel. And what the court did in Nextel is they said, parts of this provision remain viable, and the tax that Nextel paid is exactly the tax that was owed under the percentage. The exact same thing is true in Alcatel. When I say these two cases are on all fours, I can't think of a more identical circumstance. And
well, the argument that's different is at least how the court dealt with it in General Motors was that the taxpayer in Nextel didn't fully develop the due process remedy argument, the McKesson argument.
I understand that that's the argument, Your Honor, but again, that's putting the cart before the horse, because if you look at Smith, it's very clear that the threshold determination is prospectivity and retroactivity. You don't need to reach, you don't need to get to due process until you make a retroactivity determination. So the reason Nextel didn't discuss due process is because the conclusion the court reached in that case was, we're going to apply this purely prospectively. It's not even going to be applying to Nextel.
Well, Nextel didn't apply it prospectively. Nextel said, which was the first case, Nextel said, we're going to blue line the tax statute this particular year. We're going to remove the dollar cap, and that remedies the unconstitutionality, and you paid the percentage, you didn't pay the dollar cap, therefore that's your remedy. They didn't talk about retroactivity or anything like that. But
remember, Your Honor, that the decision that was presented to this court by the Commonwealth Court allowed for a retroactive refund, and the court
well, I'm not sure that's true, but I think it allowed for we refund taxes all the time in Pennsylvania when somebody pays more than they're supposed to pay.
Right, but Nextel had asked for a refund, and this court overruled that part of the Commonwealth Court's decision. So, and they were perfectly right to do so, and they did so quite correctly based on the severability analysis. The severability analysis in this case and in Nextel is exactly the same.
So in GM, this court said that we did not decide the retroactive, prospective aspect of Nextel, and expressly found that Nextel was retroactive.
You expressly found that Nextel was reactive with respect to General Motors, and you said at 380 in the conclusion that you were making that decision with respect to the case at bar. And what we're saying is there are reasons why General Motors reached a different decision, but there's absolutely no reason why there should be a different decision between Nextel and Alcatel.
Then I'm confused. Were we right in GM to say that Nextel was retroactive? Because we did.
What I want to say, Your Honor, is that we have to live with the fact that Nextel and General Motors are both extant, both good law.
You don't have to if we overrule General Motors.
Your Honor, that's our alternative argument. And if the court can go there, we would very much like that it should go there. But we have to live with the case law as it is, and with respect, so did the Commonwealth Court. And what they did not do was choose between a decision that was significantly different and a decision that was precisely identical. And they should have applied Nextel in this case. We think there are problems with the way General Motors is, frankly, inconsistent with other decisions of this court. But we also think
why don't you talk about that? What part of GM do you think we should overrule?
Well, I think, as we say at page 20 of our brief, the most...
Well, I'm asking you. I don't recall what's on page 20.
Yep, no,
as luck would have it.
Excuse me, Your Honor. Page We think the most fundamental error is that General Motors did not apply the general rule for tax statutes. And that general rule for tax statutes is that any decision that invalidates the tax statute should be applied prospectively. And that was the decision.
Well, why is that good law? I mean, I don't quite understand it. I mean, former Chief Justice Saylor sort of made that argument in dissent in GM. You made your argument with GM too. I mean, I don't understand how that could be. I mean, because we can never put the Commonwealth to the task of repaying money, we will therefore pretend that all of the decisions that declare tax statutes unconstitutional to be retroactive.
Well, I would shy away from the word never, Your Honor. And what I say is the general rule, and the best explanation I can give you is what the court gave in OzGas at 285, and more particularly at 283, because what this court has said and other courts have said is that the reason you have as a general rule prospectivity with respect to the invalidation of tax statutes is that most of the time the taxes have been collected and spent, budgeted for some reason, and that if you didn't have a general prospectivity rule, and I'm quoting OzGas exactly, you would have potentially devastating consequences for the tax authority. And that's the reason that the court gave in OzGas. And one other really important point about OzGas is that this court held that the prospectivity rule applied in OzGas at 283 before it ever discussed any other factors. So it made it very clear that it was the general rule that was being applied by this court. They went on to discuss other factors that they said buttressed their decision, but that's been the general rule in OzGas. That was the general rule that was applied in Mount Airy. That's the general rule that was applied in...
Is that the general rule that was applied in OzGas, or was OzGas, was the ruling in that actually a new principle of law?
No, Your Honor. They did discuss a new principle of law, but they made very clear, again, as I said at page 283, that the initial decision was this general rule. They then went on to consider what are called the Chevron factors, but they made it very clear at 283 that that was to buttress the decision this court had already made.
But, counsel, you can't read OzGas in isolation. You have to look at the Ioga case, too. And Ioga was the case where this court declared, not as a matter of constitutionality, but the tax that was issued in OzGas, the validity of it, whether the local governments were authorized to impose this particular kind of tax. Ioga said no, not on a constitutional ground, but a statutory construction ground.
Right.
And that was our ruling. And then the question in OzGas, what happened was one of the property owners that was being subject to that tax, after the ruling came down in Ioga, brought a refund action.
Right.
And there the question of retroactivity seems to sort of make sense, because you have one decision from this court declaring something invalid, and then you have somebody after that declaration initiating an action based on it and saying, oh, the Supreme Court just declared this particular thing improper, not unconstitutional, improper, and we want a refund. And what this court said in that circumstance is you don't get the benefit, you can't come in now and get the refund because the refund statute you were pursuing said specifically you only get a refund of taxes that were not properly paid or not lawful, to which the local government is not entitled, right? And we said at the time they imposed the tax, it wasn't yet declared unconstitutional. So you can't now come in and seek a refund under the refund law. This is a different – don't you think this is a different circumstance? You had a taxpayer here who is challenging a particular provision that has never previously been declared unconstitutional, saying it is unconstitutional, and prevailing and being denied a remedy.
Excuse me, Your Honor. May I make 2 points?
Yeah.
One is that I think there's no question that one of the, again, Osgas does this too, one of the Chevron factors to be consulted is whether or not there's a new principle of law. But Osgas did that as a secondary analysis after applying the general rule. And the general rule was also applied in Mount Airy and Sands Beth Works, where there was no change in the principle of law. And that's also been true in other cases of this court, where they've looked to the, what I will, in a shorthand way, call the equities. That was true in McKeeson, even though there was no new principle of law. And that was true in Blackwell.
Counsel, I'm trying to get to the retroactivity point that the court addressed in Osgas.
Yeah.
In Osgas, the retroactivity was, now that you paid the tax, you didn't challenge it. The Supreme Court says the tax was improper, that the agency who taxed you didn't have the authority to do it. Then you bring a refund action. Here we have a taxpayer who is challenging a particular provision of the tax law that was never previously declared unconstitutional and trying to apply precedent to say, well, you've declared these other provisions unconstitutional for the very same reasons you should declare it unconstitutional here. Isn't that taxpayer entitled to relief? And it's not a question of retroactivity.
No, Your Honor, because I think, again, the first question this Court needs to ask is this decision going to be prospective or retroactive? And if the decision is it's going to be prospective, then you're not entitled to any relief.
What's the prospective relief look like for this taxpayer? Because the tax statute changed.
Same thing as Nextel, Your Honor.
Well, in Nextel, the court said specifically you could get the benefit of this going forward in further tax years. But here, this taxpayer doesn't have that because the statute changed.
I don't think that, as a matter of fact, I don't think there's any. I think it would be strange if you could reach back and retroactively give someone relief for some statutory interpretation and not do that prospectively in statutory interpretation, and not do that where there's a constitutional issue, because you assume the constitutionality of a provision, and in independent oil and gas, they made their decision in 2002, but this court in Osgas in 2007 said, so the decision was made 5 years earlier. And
right, that's retroactive application. I'm asking you, is this retroactive application because neither GM nor Nextel dealt with this particular provision of the tax statute?
I think the practical effect of Nextel was that it was prospectively applied. And there is no difference between Alcatel and Nextel. The difference between General Motors and this case is that there was what I will call no safe harbor. What this court saw in Nextel was they said, okay, we can't save the dollar threshold, but we can save the percentage threshold. In General Motors, there was nothing savable because all they had was the dollar threshold. So that's the reason why General Motors decided that they had to apply the decision retroactively. That's the important decision to be made. And that decision has already been made in Nextel.
I'm going to ask one more question, and then I'm going to not anymore. But as a matter of general refund law, if you apply Osgas the way you want it to be applied, can any taxpayer get a refund on a uniformity challenge?
Under the general rule, no. The general rule would be prospective application.
So all of the cases where we have issued refunds on uniformity challenges to local taxation, they were all wrong.
That's why I say general rule. I'm not saying that that should be the rule in every instance. And if I'm trying to reconcile General Motors with Nextel.
Maybe it's not reconcilable.
Or maybe it is. Why?
Well,
if you could just follow up on Justice Robson's question.
Let me take a shot at the reconciliation, and then.
When could a taxpayer recover on a successful uniformity clause challenge?
Well, I think when, for example, if you determined that there was no safe harbor, you determined that you're going to have a taxpayer that's going to have to pay a tax that the law has been declared unconstitutional on tax that's been paid, which is what happened in General Motors. Then, following General Motors, maybe that's an exception to the general rule, and maybe, given the exception to the general rule, you look to other factors, other equitable factors, and you make a determination as to whether or not retroactivity makes sense.
There was no safe harbor in Nextel either. There was no safe harbor in Nextel. I mean, maybe the problem is we didn't do a due process analysis in Nextel. Maybe that's where the problem is.
No, Your Honor, and there is a safe harbor in Nextel, and the safe harbor was the percentage. And you didn't need to do a due process.
Oh, I thought you were talking about safe harbor in the due process sense.
No. I'm talking.
That's sort of a challenge to me in all of these cases, because it appears to be that the department agrees with the proposition that there's no way for a taxpayer to bring a challenge without paying the tax first.
There are actually two different ways of doing it. One is you can pay the tax first, or you can.
Which means you pay out money.
Yes.
Which you cannot get back under your theory that you cannot get back money on a uniformity challenge. That's
because, Your Honor, if it's a prospective decision, and this is what McNulty says.
Okay, well, okay, so you have to pay the money. And so then you can't get, doesn't that just immediately conjure up McKesson?
No, because McKesson involved a retroactive. That's why I say the first decision the court needs to make is whether or not its decision is going to be retroactive or prospective.
Your answer to that would be you never actually have to talk about whether it's based upon a new principle of law or if this is a application of the uniformity clause that's gone on for centuries. Your answer to that is, I don't care what you call it, in tax cases, nobody gets a refund, therefore let's pretend that these are all retroactive.
Your Honor, that's the decision this court made in Oz Gas. That's
I don't agree with you, but that's okay.
Okay.
So you and I are on the same page. I understand what your argument is.
Okay. So if you're going to try and reconcile Nextel and General Motors, the way you would do it is you would suggest that in special circumstances, as an exception to the general rule, maybe we look to these other equitable factors. But Madam Chief Justice, you asked the question, maybe they're not reconcilable. And frankly...
And that's a question by a justice who wrote Nextel and joined GM.
I know that, ma'am. And frankly, again, we're arguing this in the alternative because we have to live with the law as it is, but we think it's very hard to reconcile Nextel and General Motors. And we think General Motors is inconsistent, as I've been saying, with Oz Gas, Mount Airy, Sands Bethworks, and McNulty. That's 30 years of this court's precedent, Your Honor. And
well, you say there's nothing we can do about it, but of course there is, if that's the case.
And again, given these inconsistencies and what we would respectfully suggest is a certain incoherence, you know, the simplest and easiest thing for this court to do would be to set aside General Motors. But if it doesn't set aside General Motors, what it should do is carefully cabin General Motors. And if you're going to walk away from this general rule that says in tax cases we generally apply things prospectively, then you're going to have a lot more than potentially devastating consequences.
I wasn't alone in joining GM.
I know
Four
that.
of us did.
I know that.
Well, I even have a more tortured involvement in GM and Nextel.
It might be right. It might be right.
Two of us did not join it.
I'm aware of everybody's history on General Motors and Nextel.
I'm just saying that we could be open-minded.
Which I share with you because I argued both Nextel
I remember.
and General Motors.
Mr. DeLone, can you answer my question, though, that you did not answer, which Justice Donahue asked you to?
Okay.
we have uniformity challenges on taxes rather frequently, most often in the real property tax context. And when somebody wins, they usually get a refund. In the cases that I've handled dealing with those, we never engaged in any kind of retroactivity analysis. We never engaged in any kind of Chevron analysis. We never applied Oz-Gas. We simply said, you challenged your tax as a violation of the uniformity clause, you get a refund. Have we been doing that wrong forever?
I think if you follow Oz-Gas, you need to look as you know, you need to see whether or not and what practical effect your decision is going to have on the taxing authority.
So your answer is yes, we've been doing that wrong.
I think my answer is yes, you've been doing that wrong.
Isn't the reason your answer is yes, we've been doing it wrong is because in Nextel, because only the flat tax cap was found unconstitutional, and Nextel had paid under the percentage part of the statute, so their tax that they paid in Nextel was appropriate. It wasn't an unconstitutional statute.
That's entirely correct, Your Honor, and that's also entirely true of Alcatel.
Okay, and so I have, in confession, reconsidered my vote in GM, and I question whether what we did was appropriate there. But just bouncing over top of GM, just to summarize so that I know that I'm tracking what you're arguing, in AL, because the statute is very similar to the statute in Nextel, and the only part of that statute that's stricken as unconstitutional is the flat tax cap, and in AL, they paid pursuant to the percentage part of the statute, which was found to be constitutional, so that the tax was appropriate and no refund is then due.
Correct.
Thank you.
Unless the court has any other questions, we think this court should apply Nextel to Alcatel prospectively, carefully cabin General Motors, or with all due respect, overrule it.
Thank you very much. Well done, Mr. DeLone. Should we hear from Mr. Solly? Now, don't try to tell us Nextel was wrong, because, you know, we were pretty invested in Nextel.
Well, Madam Chief Justice, and may it please the Court, I'm Kyle Soley, and with me is Paul Melnizak, and I'm going to tell you you were right in both cases. If the Court would indulge me, I think I can walk through both cases and explain why I think they can be not only reconciled, but they give this Court all the principles that it needs to decide this case. So there's four principles I'm going to walk through. The first one is that we all fortunately agree on, is the flat cap unconstitutional? And everybody in this room, including Mr. DeLone, agrees that it is, and this Court's decision in Nextel tells us that. The second question, and I think sometimes here there's a little bit of a semantic, some semantics that are confused, is about this word retroactivity. I'm going to use the word retroactivity as the United States Supreme Court did in the Jim Beam case, which counsel cited in his brief. What Jim Beam said about retroactivity is it's really a choice of law question. It's a choice of law question. It comes up when a court has reversed another decision or has otherwise changed the law. And when we hear about retroactivity, we think, which law do we use? Do we use the new law that we just announced or the old law? This Court in GM said, when we announced that rule in Nextel, we were applying a century of precedent. We were not announcing new law. So in that way, Nextel is retroactive. I say that only because we get retroactivity and refunds kind of tied up. But the Nextel principles are retroactive because there's nothing new in Nextel. So in Nextel, Justice Todd, what you wrote, because I think a quote is useful, when you went to apply those Nextel principles to the case at bar in Nextel, you wrote, by striking this provision, that is the cap, all corporations for the tax year 2007, remember you wrote this in 2017, so in a sense it's retroactive, would be limited to taking a net loss carryover deduction equal to 12.5% of their income for that year. And you went on to say that assures that all corporations will equally share in the obligation to pay corporate net income tax for 2007. So what we would...
Counsel, Nextel explicitly disavowed that Warner Brothers case from 1942. How's that not a break from this one? We're on your second point here, right? How does that not a break from?
Fair enough, but we would say in GM, this court looked at that and said that is not the kind of evulsive change in the course of the law that, because this court in Nextel looked at what was written in Warner Brothers and said, look, that uniformity issue was dismissively dealt with in two sentences. And the law, the case law before Warner Brothers, Cope's estate from 1899, and the case law after Warner Brothers, 1962, Salisbury, just ignored what Warner Brothers had said because Warner Brothers didn't.
No, that's a fair point, and I understand that's the view the majority had, which is now down, I guess, sounds like it's down to 3 from 4 or whatever it was.
I'm not giving up on Justice Monday, so
we're rethinking GM, not Nextel.
Let me just say though that I understand the argument, but how does that impact the reliance interest? I mean, taxpayers, litigants, lawmakers, whether you and Chief Justice Behr or the majority in GM thought it was a spare reasoning or spare analysis is one thing, but the rule is the rule. So presumably for 40-odd years, 60 years, taxpayers and litigants, lawmakers were relying on the ruling, weren't they?
I would say no. I would say they weren't because you would look at this court's decision in Salisbury in 1962, Amidon versus Kane in 1971, all of which reiterated this idea that you can't have a threshold in the tax, that all those thresholds cause taxpayers with larger income to pay tax and taxpayers with smaller incomes not to. In all of those cases, this court ignored what we would say essentially was an unnecessary or at least a dismissive analysis of that uniformity provision and rather just looked at Cope's estate and its progeny. So when the General Assembly was sitting in 1995 writing the cap on the net operating loss deduction, the most recent decisions of this court were Amidon versus Kane in 71 and Salisbury in 62. Yes, it had the Warner Brothers. Maybe they should have taken pause, but then before that, this court had struck down the $5,000 threshold in Cope's estate. And certainly, I don't think that it would be fair for the legislature to say we have no idea that in Pennsylvania you can't put a threshold or a cap on a tax. I think that the General Assembly knew very well that that was the situation. In fact, the first case that I handled involving that flat cap on the net operating loss was for the 1995 tax year. I mean, it was immediately after that thing was passed that the tax lawyers were swarming all over it because we all knew about that authority. So at least in this case, I think the reliance interests don't favor the Commonwealth. And that's what this court found in GM. This court found in GM that, look, we look at all this, we look at Warner Brothers, and we think the Commonwealth was on notice that you can't do this whole threshold routine because that creates different classes of taxpayers. And therefore, since it's not a new principle of law, it is retroactive. And again, only in the sense in which when we go back to the 2007 tax year, we can strike the flat cap from the statute in the 2007 tax year, and as Justice Todd, as you wrote, all taxpayers for 2007 are treated the same.
Counsel, can I just, again, just sticking with your retroactivity, Nextel didn't declare the tax year at issue in this case unconstitutional. So why, is there a difference in your mind of applying precedent to a case versus making that earlier decision retroactive?
Going with my definition of retroactivity, which I think is the standard one, and retroactive being a choice of law question, I think there's no difference. because I think the question under retroactivity is, what law do we choose in looking, in Nextel we have the 2007 year, in this case we have the 2014 year. The question is, what law do we use, what law do we choose to decide whether that statute is unconstitutional or not? And I would say, since the law hasn't changed, the law we choose is the only law there ever has been in Pennsylvania, again, with the assuming that Warner Brothers doesn't give us a different result, the only law there's ever been in Pennsylvania, which is you can't do thresholds. That's our choice of law, and I can apply that choice of law, that is, thresholds and caps are unconstitutional, equally to 7 as I do to 14.
And all of that, though, was, again, all of that was analyzed in Nextel. So it would make sense for you to cite Nextel for purposes of saying this year's dollar cap is unconstitutional.
That's right. We would say when Justice Todd wrote what she wrote in the Nextel opinion and said you strike the cap and you leave the percentage, that's retroactive in the sense that's the law we choose to use for this year. And then what Justice Todd did was said, look, okay, what did Nextel, what was their tax situation? Well, they paid on a percentage cap, okay? And I, Justice Todd, and the Court have just determined a percentage cap is the right answer, having stricken the flat cap. And, well, Nextel paid exactly what I've just determined the law is. And since there was no other principle of law that was introduced in the Nextel case, and I was also the counsel for Nextel, and I can tell you, we didn't, that was not a principle of law that was introduced in the statement of questions. There was, to Mr. DeLome, he pointed out some supplemental briefing, but this Court clearly did not deal with due process in Nextel.
So you fooled me. Yeah, you fooled me in the Commonwealth Court then.
There is.
Take your time. Take your time with that answer.
Well, you fooled us up here too.
Retroactivity.
See, I didn't talk about retroactivity in the Commonwealth Court in Nextel. I said, are you entitled to? You have succeeded.
Right.
And because you have succeeded, you are entitled to relief. I didn't talk about whether every taxpayer that came after you as a result of Nextel could get the same relief you got in Nextel. To me, that's retroactivity. I said, and I didn't make this up, I'm not that bright. You guys fed me this argument in Nextel. You told me you wanted a refund. And I treated it like every other tax case where someone challenges whether they're challenging their tax as a violation of uniformity or they're challenging their tax as a violation of statute, refund.
The way we addressed the issue in Nextel was I'll put it this way, we took due process for granted. And there are uniformity cases that we cited to and said as a matter of uniformity the taxpayer is entitled to a refund. But we didn't get into due process, and I'll be the first to admit, and now I am here, almost 8 years later, maybe regretting the strategic decision, but we frankly took due process for granted. And perhaps shouldn't have. What we should have done is presented to this Court, okay, now that you've done that, now that you've struck the cap, now that it's 12.5% in Nextel for everybody, we are still in a situation where we'd paid tax and 10,000 taxpayers didn't, and somehow that needs to be fixed.
Are you suggesting that would have led to a different outcome? I mean, because we were pretty clear there. We said we reject Nextel's argument that failure to reward its challenge with a refund will somehow chill the bringing of future such actions to contest the constitutionality of taxing statutes. So you think the mere invocation of the mantra due process would have shaken that?
I don't think the mere invocation of the mantra. I do think, however, that if we had briefed we had briefed McKesson to this Court, that this Court would have done what it did in GM, which is said, okay, now that we're done the severance analysis, and now that we see that because I think it's a different question about motivation to litigation compared with whether or not due process has been satisfied. So I think this Court was right in saying perhaps other litigants may bring it and there may be a benefit going forward. But I think what we should have done in hindsight in Nextel is had Roman numeral 3 in our statements of the question presented and said, and now you need to take it the additional step.
Have we ever done that when applying OzGas? Had we ever done that?
We did that in GM. And that's
Well, we did that later in GM.
Yeah.
But up to the point you did Nextel, we didn't.
Well, okay, so I can talk about, so in GM we did, and we would say that's the last piece of the puzzle, is that if you apply GM, you need to make us the same as similarly situated taxpayers, either by increasing their tax. That's what McKesson said. McKesson said this is not a windfall for taxpayers. It's either you take the exemption away from the taxpayers that got the benefit, or you assess the ones, or you give a refund to the ones who didn't, but you can't leave the discrimination stand. Now,
skilled, but strenuous attempt to disavow GM's existence as an outlier in this area. Do you not concede that GM is, looking back now, is clearly an outlier?
Absolutely not. There is no case in the there's no case in the Commonwealth where a taxpayer has brought an action under a refund statute for state taxes that have been declared unconstitutional under long-standing law where the taxpayer has not gotten a refund. Every case. Now, Mr. DeLone cited cases, let's talk about them, Ozgas. Well, first of all, that case did not involve long-standing law. First of all, Ozgas is not even a constitutional case. It's a case of statutory construction, so it's kind of a little bit of an oddball. But it was clear that that case involved new law. You had a case called E.H. Rockwell from like 1910 that was a law for 100 years. And this case reversed it in IOGA. And then Ozgas came in and said, where's our refund? And this court says, you don't get a refund because we've changed, you did a Chevron oil analysis, we said we've changed the law, and the local governments had the right to rely on that long-standing law. Now, going forward, there's no tax, but those local governments had a right to rely on the long-standing law. Mr. DeLone cited McNulty. McNulty involved highway taxes. Interestingly enough, the original case, the highway taxes arose right out of Pennsylvania. Highway taxes out of Pennsylvania were struck down by the United States Supreme Court. But in doing so, the United States Supreme Court reversed a case from the 40s called Arrow-Mayflower. Arrow-Mayflower had said flat taxes on trucks are good. And Pennsylvania relied on it and imposed flat taxes on trucks. And then the case came out of this court, went up to the U.S. Supreme Court, and said flat taxes on trucks no longer good. But the Supreme Court, the United States Supreme Court, in a case that followed called Smith, said because there was a change in law, because Pennsylvania had a right to rely on Arrow-Mayflower from the 40s and collected all these taxes under the color of that law, when that law was reversed in the Shiner case in the early 90s, that reversal of the law will only be prospective. And so Justice O'Connor in Smith said, because of the change, it's prospective only. What's interesting about that case, about Smith, is it was decided the same day as McKesson. And in McKesson, so in Smith they said it's not retroactive because it's a change, and in McKesson they said longstanding principles of discrimination, and it is no one even talked about whether it's retroactive because it was longstanding principles, and the unanimous court, including Justice O'Connor, who had said it's prospective only in Smith, the unanimous court in McKesson said you get your refund, or at least there's a retrospective remedy, which may be refunds or not. But I would say the cases in which, there was some talk about Mount Airy and Sands, and those cases are different in this way. Mount Airy was a declaratory judgment action. It did not involve a refund claim. Now, like any good lawyer, right, the litigants in Mount Airy, they said, hey, look, while we're at it, while we're here in front of the court, remember, it was special jurisdiction to this court, declaratory judgment, and hey, while we're at it, will you give us our money back too? In this court, Justice Wecht, in his footnote, famous footnote 11, says, there's not like a free-ranging right you have to get a refund. We don't have a Section 1983, a Civil Rights Act kind of action where you can just come into our courts and get money back. You've got to find a refund statute. That's why every time a taxpayer has actually brought a refund under a refund statute, the courts in this Commonwealth, unless there's a change in law, have given refunds. But in Mount Airy, you didn't, I would say, because it was a declaratory judgment action. The potential outlier is the Sands-Bethwork case. Funny enough, because you did give the refund in a declaratory judgment action, and you did, I think you got the right answer maybe for the wrong reason. You gave the refund and you said, well, I think it was Justice Saylor, we're giving the refund because, you know what, we put the money in escrow, so it's not going to be that big of a deal. Here's the problem with that. Right answer for wrong reason. The wrong reason is there's a decision of the United States Supreme Court called Reich. And Reich says if a state has a refund statute and holds that refund statute out to taxpayers and says you can use this refund statute to get your money back, what you can't do is, after taxpayers have paid in the money under the refund statute, say, you know what, I know we had the refund statute, but it's going to cost us a lot of money. It's really going to be a burden to get the money back. And what the United States Supreme Court said unanimously in the Reich decision is, if you pay tax under a state refund statute, and that tax is held to be unconstitutional, you can't hide under the, well, maybe you could have put it in escrow, you could have done something, there's some different process. No, the state, look, if the legislature wants to get rid of the tax refund statutes, it can do it. Then every piece of litigation, tax litigation, will always be pre-deprivation in the Commonwealth. We'll never hear these complaints about, oh, the pockets are empty, it's $300 million. They can do that, and McKesson said that, right? McKesson, in the balancing discussion that Mr. DeLone talked about, McKesson said, you've got all kinds of tools you can use to mitigate this impact, state. Pass a law that repeals the refund or makes the statute of limitations on refund short, or requires that the money go into escrow like Sands-Bethworks. But I would say actually that the outlier is this idea that we don't pay money back once a statute has been found unconstitutional, following a long-standing principle of law.
Chief, I just have on the retroactivity, which I'm struggling with. What about those cases that are laying in the pipeline right now? Let's say you're successful, and let's say you get a refund. I'm thinking of this court's decision in Protz. There's a lot of discussion. We still get questions about whether Protz should apply retroactively. And the principle that the Commonwealth Court has applied is, and you know what Protz is?
I do.
Okay. So the principle is that Protz applies to cases that were in the pipeline, where people were already challenging the constitutionality of the IRE statute. They had it in place. In other words, nobody can benefit from it if they didn't have something pending at the time. Can that principle somehow be applied in this case if you're successful in getting a refund?
I would say it does apply. I would say, so I'm aware that in the wake of Protz, there's a lot of employees who have wanted to, I always call it, resurrect claims that have either by way of res judicata or by way of statute of limitations have otherwise expired. In the Jim Beam case, it's either in Jim Beam or in Smith, the United States Supreme Court said, when we say retroactivity, we don't mean that you can go back and you can take cases that are otherwise out of statute, that are otherwise closed because of res judicata, and open them back up. All the normal rules of, hey, do you have a live case, still apply. It's interesting. There was a case that this court decided in the 60s. It's Box Office versus Board of Finance and Revenue. And believe it or not, the Commonwealth imposed a tax on allowing to essentially fund censorship of movies. And that tax was found to be unconstitutional as a violation of the First Amendment. And it applied, and taxpayers that had refund claims that were timely got their money back. But claimants brought refund claims and said, way back, for out of statute, you say, hey, we paid this, we want to go to out of statute or otherwise closed years. And this court said, well, we can't, when we hold something as unconstitutional and it's unconstitutional from the get-go, that doesn't mean you can avoid other procedural protections like statutes of limitation. So I think Judge Robson, bring it back, just like employees in Protz are going to be limited to the other rules that would apply to a workers' compensation case, whether it be res judicata, whether it be a statute of limitations issue. Those same kind of limitations, principally statutes of limitations on refunds, would apply in tax cases.
All right. Are there any other questions? Thank you. Thank you, Mr. Sully.
Thank you.
We understand your case. Both of you did just an outstanding job, and I think it's only fair that any of the lawyers in attendance get continuing legal education credits in tax for attending this open.
It was very educational. Thank you.
This is a direct appeal from the imposition of a death sentence imposed by the Cumberland County Common Pleas Court. The jury convicted appellant of 2 counts of first-degree murder in connection with the fatal shooting of his paramours, one of whom was pregnant at the time of death, as well as the first-degree murder of the unborn child. Appellant was also convicted of 2 counts of endangering the welfare of children based on the fact that his young son was in the room during one shooting and his son was left alone in appellant's apartment after the other shooting. The jury deadlocked on the sentence for the first murder, causing the trial court to impose a sentence of life imprisonment. The jury reached a verdict of death on the second murder, finding that the aggravating circumstance of appellant having a prior conviction for which a sentence of life or death was imposable outweighed the catch-all mitigating circumstance involving appellant's tumultuous childhood and abuse. In this direct appeal, appellant challenges the weight and sufficiency of the evidence supporting his convictions, the admissibility of his inculpatory statements, and the existence of the aggravating circumstance found by the jury in connection with his death sentence. You may proceed.
Yes, thank you, Madam Chief Justice. If it please the Court, Attorney Palermo from Cumberland County. I was part of the trial team that tried this case in Cumberland County, and just to be clear, although it's a sub-issue, the reckless or the endangering the welfare, there's 2 counts. What really is at issue here? Leaving the child alone in a home, I'm not really challenging the facts of that for the conviction. What we're trying to argue before the court is the mere fact that leaving a child being in a residence when a gunshot's fired and may ricochet off a wall in that same home is not per se or beyond a reasonable doubt endangering the welfare. I think that's the facts of record that the conviction at issue is there was a gunshot fired, obviously fatal, and that there was evidence of a ricochet in that room. The evidence of record, I believe, is the child was in another bedroom or pulled from another bedroom after the fact. So what we're challenging as sufficiency grounds is that the mere fact that a child is in a residence, even if it be 1 story, when a gunshot's fired with proof of ricochet is not enough to convict somebody beyond a reasonable doubt of that crime. I just want to clarify that one issue.
Thank you.
I don't think before this court is I could argue to you that leaving a child alone with a deceased person is probably an EWOC per se. I want to move on to the issue that I think, one of the issues that's really at the forefront here that I felt compelled to raise in brief before the court is that we had a unique issue at trial in this case where when we actually received the verdict slips after the fact, obviously, the verdict slip came in with the first, so just to be clear with the facts, there's a homicide on July 5th and July 30th in the same month. The July 5th homicide was that of Sydney, and the foreperson on the verdict slip for Kaylee Lyons, when they found that aggravating factor, they wrote the victim's name on the verdict slip. It was very unique. Obviously, I couldn't find another case similar to that to raise with the court, but
and obviously we can't delve into what the jury was thinking, but what better evidence to put in front of the court than them writing the deceased victim's name on the verdict slip? Then you see it kind of crossed out, then you see different numbers and subsections, that's crossed out, and then you see the correct aggravator factor they found beyond a reasonable doubt. So what that led me to bring up with the court today is that there's a possibility that that verdict they reached was maybe focused on the actual death of Sidney, and maybe a result of passion or sympathy for that victim, not a proper weighing of the factors. My personal opinion, obviously, having sat through that trial, was that the mitigating evidence was overwhelming versus the one aggravator of the Commonwealth, but I know you cannot reweigh that today. But when you have evidence before you that they actually wrote the deceased victim's name on the verdict slip.
And what are we to glean from that?
Right. Justice Daugherty, I don't know what you glean from that, but I'd raise the issue that perhaps that decision was based on passion of the jury or sympathy for that particular victim, because the jury's job obviously is to weigh the aggravating factors, which is, were they convicted of killing another person before this homicide?
What they do for the second deceased?
So the first homicide, they deadlocked.
Okay.
That was as to Sidney, correct?
Correct. By operational law, that was a life sentence. So that jury obviously was hung up on something in that first case. The second one, they reached a verdict, and it was unanimous, and it was for death. So I'd be remiss if I didn't bring that up before the court, because it was important to my client. It's important to me. I had questions about it, but the way the law is written, I cannot delve any deeper than that. On its face, the jury wrote the deceased victim's name on the verdict slip. I'd never had that happen before. By looking at just the pen strokes on that paper, there was some kind of issue that foreperson may have been having. There could have been 11 other people in their ear at the time. I don't know, and I'll never know, and we'll never know. But it's enough that I think it was valid to bring before this court, who's going to review the sentence of death and make sure there's sufficient evidence to support it.
Okay.
So,
do you want to move on to your next issue?
I do. One of the issues, Justices, I want to bring up is, in the president judge in this case who heard our suppression issues, he did exclude a lot of statements in this case. But he didn't exclude two, and one was what you can call an excited utterance to a corrections officer at the Cumberland County Prison. And the other was, I think the trial court, in their opinion, I think they called it uncounseled statements or admissions that were made to the two detectives in this case, one being the affiant, made at the Cumberland County Prison. And we've litigated this in the lower court, obviously, at the trial level, but we've asked for wholesale suppression of every statement Mr. Anderson made. And the trial court did suppress every statement in which Mr. Anderson invoked his right to counsel.
But not the statements where he tapped on the window and said, "I killed both of them"?
Correct. And I believe, Madam Chief Justice, that was to the corrections officer. There is
Is that coercive or manipulative? Or
It's not coercive, but if you look at the totality of the circumstances, and this is all within I would say, a 12 to 13-hour period from the time of arrest. I don't know if it's our prison policy, but at that point, Mr. Anderson is what they call a turtle suit, which is it's kind of a suicide prevention suit. They take your clothes, and it's more of like you'd wear it like a X-ray. It's a really heavy garb they put over you. There is, of record in this case, at the suppression hearing, the affiants mentioning this guy is schizophrenic, he's got some issues, but even knowing that, he's making these statements to a CO through glass. Those statements may be the strongest statements they have that could be admissible. Justice Weck, if I could move away from that for a very quick minute, because there are statements made that I take issue with that are made to the two detectives, and by my count, within 13 hours, Mr. Anderson invokes his right to counsel at least 5 times to those two detectives. Now,
none of that matters if the tap on the window confession is valid and was before any of that invocation.
Right.
None of it matters, and so the jury could still reach the same conclusion, possibly, Madam Chief Justice. But my issue is,
none of it matters if we find that was a valid conviction.
I'd have to concur with that decision, yes. But the issue I take is with the officers and the affiants, detectives. When you look at the factual scenario set forth by the trial court, the officers arrive at Cumberland County Prison that day with a search warrant for GSR, for the gunshot residue sweep, and his clothes. They go at Mr. Anderson, and I would suggest knowing his mental state 4 times. And each and every time they go at him, he lawyers up. He invokes his right to counsel.
Counsel, wasn't the time when the police officers came for the second unsolicited statement to execute the search and seizure warrant, wasn't that after he had tapped on the window and said to the corrections officer, I killed them both?
It was after the fact of that, correct.
I think it may be helpful, I think, if you kind of lay out the chronology, because my understanding is he was arrested at 4 o'clock. He immediately invoked his right to counsel. The first unsolicited statement to the tap on the window to the corrections officers was 6:45 p.m., which was a full, 14, 15, 16 hours later, after he had invoked his right to counsel at least twice, or maybe even 3 times?
So, Justice McCaffrey, I have the 3 p.m. as I killed them both statement, and then you have all the way towards the end.
That's 11 hours post-arrest.
Correct.
After he's already invoked his right to counsel twice.
He has. And then, and again, these are the same 2 detectives he keeps invoking his rights to. What they do, and what I suggest to this court is, by having that in pocket, by keeping that warrant for his clothes in pocket and never presenting it to him, they keep getting more bites at the apple to go back at him. And that's where I think the officers in this case were able to create this scenario where they keep going back at him, because it's proving by now, there's some record, Justice McCaffrey, that, hey, the more we go at this guy, the more we might get a statement from him. So if you truly have that warrant, I think the trial court made that conclusion that they have warrant in hand on that first visit, but they never present it. They keep going back at him, keep getting rejected.
Let me ask you this question. Did you elicit that information at the actual suppression hearing? In other words, was there any evidence presented? He was arrested at 4 a.m. He said, I want a lawyer. Was there any evidence presented whatsoever that a lawyer was contacted, the public defender's office in Cumberland County was contacted? What did they do to get him a lawyer between 4 a.m. and the time he made that statement at 3:45?
I believe they did nothing at that point, Your Honor. There's no record that anything was done. You may believe that, but I'm asking you, was any evidence presented to that effect? I don't believe so, no, not from my review of the transcript. I do know that President Judge Guido makes reference in his opinion per 1925 that he believed that this warrant was always in their possession while they were in the Cumberland County Prison. They just never presented it. And it was the last time they presented it is when they get this, what he calls an uncounseled statement, which was admitted at our trial in this matter. And
but the warrant had to be approved at a certain time by a magistrate, correct?
Correct.
Is that entered into evidence of what time it was approved?
The warrant, I believe, is of record in this case. The time of the warrant being issued is not in front of me at this point. I apologize.
Was that presented at the motion hearing?
I believe it's an exhibit presented by the Commonwealth. But that was the issue, not to shy away from the first, what I'd call an excited utterance to the CO. But again, knowing that mental state of that defendant, knowing this gentleman clearly knows how to invoke his right to counsel, did so, I counted 5 times in about 13 hours. And still, we're not doing the wholesale exclusion of evidence. We're letting in certain parts of what we're calling an excited utterance to the CO, which is damning. Madam Chief Justice, I'll agree with you. But no need to compound upon that by admitting the other ones to the same detectives that were previously suppressed. So my issue I really take is with the issue towards the end of the day, towards the end of the evening, the later hours of the next day, where those statements still come in to these same officers who he now has invoked his Fifth Amendment 5 or 4 times at that point too. So that was an issue that I'd like to bring to the court's attention. The other issue, if I could address it, I know we don't have a marching order of these orders, but we did want to raise, there was a question in this case, and we put it in brief, that it kind of belies the possibility that there was any premeditation in this case. I know that may sound odd to the justices. This was 2 females, 2 paramours, murdered in the same house in the same month by essentially the same means in the same room. We looked at that as what a lack of a forethought, that who would plan 2 murders in this way if they were truly planning murders. In both scenarios, in both factual cases for the homicides, there was evidence of recorded, there were fights immediately before somebody heard a gunshot.
Why wasn't that within the province of the jury?
It was, we were, to be candid, we did get an instruction on voluntary manslaughter in this case, and the jury rejected it. So we did raise the issue in the trial court and on appeal with this court. So I just wanted to bring that up for the court, that we thought, who in their right mind would plan 2 murders in the exact same way at the same house and expect
The jury
not to
thought
be
he
caught?
did. The jury thought he did.
Clearly.
And the plan doesn't have to be a 2-week-long plan. It can be a 10-minute plan.
Understood that, but there, Madam Chief Justice, there was evidence in both cases of a fight immediate before these shots were fired.
Okay, we understand that argument. Anything else that you have for us?
That's all I have for the court.
Any
Thank you.
questions among the justices? Thank you.
Thank
Oh,
you.
did you have one?
No.
Nope. Okay. Thank you, Mr.
Counsel,
Blair.
thank you for your efforts on
Yeah.
behalf of the defendant.
Appreciate it. Ms. Robinson.
May it please the Court, Attorney Palermo. First, I would like to clarify some questions related to the suppression and the statements. I agree that if the court finds the trial court was correct and appropriate in allowing in the initial statement to the corrections officer, which I submit was an excited utterance and clearly admissible in this matter, that the second statement is not necessarily all that damning. But I do think that we need to clarify the second statement and the timeline. The defendant was arrested initially in connection with being in possession of one of the deceased victim's cars that had been reported stolen. He was taken to Cumberland County Prison, and when a corrections officer came on scene, came to work, he observed the defendant engaging in what he believed to be suicidal behaviors. That's when the defendant was moved to the medical area and placed in what was referred to as a turtle suit. A few hours later, defendant tapped on the glass, approached the corrections officer, and indicated he wanted to confess. The corrections officer testified at the suppression he does not want to get involved in criminal cases, so he reached out to the police officers that eventually did come to the prison. I do think that the trial court correctly suppressed the statements that were suppressed that occurred when defendant did invoke his rights. I do agree with that ruling. If you look at the record and watch the body cam footage, the second statements that were at issue there, where the defendant specifically named the victims that he murdered, the police were filling out paperwork in connection with those search warrants, and the defendant, on his own, unsolicited, without any contact from the detectives, said, "I killed Kaylee, I killed Sydney."
Commonwealth, was this before or after he invoked his Miranda?
So that was after he had been interviewed by the detectives and invoked Miranda.
So the question that I have is, as Justice McCaffrey brought out, if we endorse your position that this was voluntary, are we implicitly now saying that the police, as long as you keep someone in custody long enough, that you can ostensibly ignore someone's request to have counsel until knowing the individual is suicidal and there's some emotional issues going on? Is that what you're asking us to do?
No, Your Honor.
Then share with us, one, as Justice McCaffrey asked, what evidence was there that the Commonwealth or anybody attempted to call the public defender or permit this guy to enjoy his constitutional right to have a lawyer?
So from my understanding, there was about a 45-minute time lapse between him invoking his right to counsel and them ending what the suppression court refers to as the third interview. And then they come back in to do the search warrants. I'm not saying that's great police work. By no means. That was not a good method.
Sorry, can I just interject? I don't mean to beat you up on this. You said the third interview. He was arrested at 4 o'clock, right?
I don't remember the exact time that he was arrested. I do know that the corrections officer arrived to work at 3 p.m. to 11.
I'm not talking about the corrections officer. I'm talking about he's arrested around 3:30, 4 o'clock in the morning. And he says, when at the time of the arrest, I want a lawyer. Everything you're talking about happens 10, 11, 12 hours later after the detectives had tried to talk to him and he said, I want a lawyer. They came back at him again. He said, I want a lawyer. And then he tries to commit suicide. They put him in a turtle suit. They move him over to another wing. He taps on the window and says to another corrections officer, I killed them both.
No, Your Honor, respectfully, it's sort of the reverse. The attempt to speak to the corrections officer and the attempt of suicide, or what he believed to be an attempt of suicide, that all happened before the police ever came and spoke to him.
What time did that happen?
So the corrections officer testified at the suppression that he came in at 3 p.m., and he had been there until about 6:30 p.m., which is when the defendant approached him.
So at that time, when the corrections officer comes into work at 3 p.m., according to what we've seen, the defendant has been in custody for at least 11 or 12 hours.
I don't know the exact time that he was arrested, but at that point in time, he had been in the jail, but the detectives had not been to the jail to interview him yet.
Commonwealth, your brief indicates, I believe, July 31st, 4 a.m., he was arrested. And subsequent to that, he invoked his Miranda rights. And then, I believe what you're calling the third interview or whatever, at 9:45 p.m.,
right,
the detectives decided to execute the warrant for the DNA for which they were possession in from earlier.
Correct.
To say, now we're taking your DNA, at which time he confesses. Do you feel that there's some element of coercion on part of the individuals, the detectives, knowing he has a mental instability after X number of hours in custody while he's in a turtle suit, or I guess it's common straitjacket? Do you think we need to take that into consideration as to whether this was a voluntary expression of his criminality?
I certainly do think those are things to consider, Your Honor. I don't know what the Cumberland County Prison's policy is on when they think they need to intervene as far as do some other precaution if they feel like someone has some type of suicidal tendency or problem like that. I know that as far as getting that person counsel, they typically wait until they have set times of the initial arraignment, and they wait until that time occurs to have the person request from the magistrate counsel and things of that nature. I know that's their policy related to finding the person counsel.
How much time elapses traditionally in Cumberland County between the time of the arrest and the time of the arraignment? I can't help but think if somebody's been in custody for 12 hours, 14 hours, 15 hours, that there couldn't have been an attorney assigned to them in those 14 hours.
I believe that they have a judge scheduled to do arraignments in blocks every 6 hours, is what my understanding is.
But even if we accept everything that you've just said, when you go back to his first confession, that was not to the detectives, right?
Correct.
That was when he tapped on the window and said to the corrections officers, I killed them both.
Yes. That was, law enforcement was not present. He solicited contact with the corrections officer and said, I want to confess, I killed them both, and the corrections officer then reached out to the police. And I think the corrections officer testified at the suppression hearing that it took some time between when he did that and when the police actually came.
But when he was first arrested, he said he wanted an attorney, and before he actually spoke again to the detectives, this communication to the correction officer occurred, and it was kind of a voluntary utterance. It wasn't in response to any interrogation.
Correct.
My understanding is upon arrest, he invoked his right to counsel. Police did not process him for some time, but kept him on suicide watch in a medical holding cell near the booking center. He then was placed in an anti-suicide smocking at 3 p.m., unprompted allegedly. Anderson called C.O. Corsiglia's attention and told him I killed them both. And 4 hours later at 7 p.m., detectives begin interrogating him. So at 4 o'clock in the morning, he invoked his right to counsel. Your arraignments are every 6 hours, and obviously they're with counsel, yet X number of hours go by and a public defender is not even notified that an individual who is alleged to have admitted a crime but invoked his right to counsel is on a suicide watch within your facility. And the record's conspicuously absent as to counsel coming to the prison to represent him despite his constitutional right. Can you share with me how that is not, in essence, coercion, if not concerning liability, had that individual killed himself while under the watch of law enforcement?
Your Honor, in reading the suppression transcript, it appears to me that the charges had not been filed or completely accepted, and that possibly was delaying the time of the arraignment. I agree with you. It is not a good policy for the jail that they did not.
I'm sorry. Had they executed the search warrant for DNA upon arrival with this warrant and not X number of hours later, they would have had the necessary information to effectuate the Commonwealth issuing a complaint, correct?
If that was the only thing that they were waiting for on the homicide charges, yes, Your Honor. You're right. Yes.
What else would you like us to hear from you?
As far as the endangering the welfare of a child, I submit that the first death of Sydney, there was evidence that the child was in the room where she was killed in very close proximity to her. I submit that shooting a firearm in the same room as a small child and aiming at the person directly next to a small child does in fact endangering their welfare. And then to the point regarding the same manner, location, cause of death, I would direct the court to a prior case. I believe it's pronounced Box. I'm going to not pronounce this correctly. It's spelled B-O-C-Z-K-O-W-S-K-I. It was a 2004 case. In that case, the defendant similarly had committed 2 homicides of paramours in similar manners. In criminal law, I'm sure you are all familiar with 404B type of evidence, things like that. It's not unheard of for a defendant to commit a similar type of crime or use the similar type of means, method, things of that nature. So I don't think that that in any way affects whether it could be a first-degree murder rather than a third-degree murder.
Can you share with us, for endangering welfare of a child, what was the supervisory or responsibility of the defendant?
It was his child. And I believe that was a stipulated fact at trial, that it was in fact his child that was in the room and in the house for both homicides.
It was the same child.
Same child, yes.
Okay.
Same child of the defendant and the second victim.
All right. I think we have your arguments. Any other questions? Thank you very much to both of you.
Thank you for your time.
Counsel.
Nice
Call
job.
the next case, Mr. Minner.
Commonwealth, Pennsylvania versus Stevenson, representing Mr. Stevenson, Mr. Pearlstein, representing the Commonwealth, Mr. Joshua.
How's it going? Having fun down there?
I understand in this case we have some of Professor Epstein's students from his criminal appellate procedure class at Temple University, Beasley School of Law, so we certainly welcome your students that are here with us. Would you like to stand? Welcome. We're glad you're here.
And by the way, on a personal note, congratulations on being accepted to the finest law school in the United States. We call it the Harvard of North Broad Street.
All right.
Sorry, Justice Weck.
In this case, after the Commonwealth presented its evidence at appellant's trial for robbery, burglary, and criminal conspiracy, and before appellant took the stand, he filed a motion in limine requesting that the Commonwealth be precluded from questioning him about a prior conviction that was more than 10 years old. The trial court denied the motion, and appellant's counsel asked appellant about his prior conviction during his direct examination. The Commonwealth did not cross-examine appellant about the prior conviction. Appellant was convicted and on appeal challenged, among other things, the propriety of the trial court's denial of his motion in limine. The Superior Court held that by introducing the prior conviction himself, appellant forfeited his subsequent challenge to the trial court's ruling. We granted review to consider whether the Superior Court's holding in this regard was correct. Mr. Epstein.
Thank you, Madam Chief Justice. May it please the Court, Jules Epstein, pro bono counsel for Mr. Stevenson. Here with me, Mr. Aaron Bell, Mr. Stevenson's counsel. May it please the Court. It has never been, it is not now, nor should it ever be the law here in Pennsylvania, whether in a civil case or a criminal case, that if a party loses a motion in limine, which means a judge has said this evidence is proper, that they somehow forfeit the right to appeal by then asking about what the judge had said may come in.
Does it really come down to kind of an analysis of strategy? I'd rather bring it out on direct than have somebody attack me on it on cross.
And that is, if you will, Chief Justice Todd, the fundamental fairness background to this.
Because it was going to come in one way or the other.
It's going to come in. The Commonwealth, the Minister of Justice, so to speak, in the courtroom has said, we want to use this.
Sure.
And I'm sorry.
No, go ahead, finish, sir.
And if I may, we want juries to decide cases on the facts, not on who brought them in. Because while you call it properly, in some sense, an issue of strategy, it's also an issue of avoiding being tarred. If I don't bring it in, and then it comes in later,
I'm going to look worse. Yeah.
I'm going to look worse in the sense of being an advocate, and I'm not worried about I heard a lengthy argument this morning about reputation.
Counsel, if I may ask, the issue of waiver is going to an error law, let's say, with regard to Pennsylvania Rule of Evidence 103A1A. It's a preservation of a claim of error with regard to motion to eliminate.
Yes.
Is your argument going that this violated, there is no waiver because by litigating the motion in limine and losing it, he in fact preserved it, and as a tactical strategic movement, you brought the issue of the conviction first. You're not waiving it by bringing the issue first. Is that not your argument?
Exactly.
Okay, that's what I thought it was.
Under Pennsylvania's Rule 103A, and we're here because the Superior Court, at the Commonwealth's urging, turned away from Pennsylvania law and said, well, we'll follow a U.S. Supreme Court decision. The problem is their 103 is different from ours in several ways.
And even if it wasn't, we wouldn't be bound by
Yeah.
that.
I certainly agree you're not bound by it, but in addition to the fact that this court has its own rulemaking authority, there are material differences, and if I may list them briefly. Number one, and most fundamental, is that our Pennsylvania Rules of Evidence, adopted in 1997-1998, were meant to incorporate the common law. That's not true of Federal Rule 103. Number two, what is our common law? As this court is aware, there were amicus briefs in this case from the Pennsylvania Civil Defense Bar, from the Pennsylvania Plaintiffs Bar, from the Pennsylvania Bar Association, where everyone is saying this has been settled law for a long time. And my civil compatriots, when they, by the way, it is a rare day when the Civil Defense Bar and the Civil Plaintiffs Bar speak in one voice to this or any court, okay? But the cases they cited, two of the three, predate our rules of evidence. They embody that common law. There are other differences. Our Rule 103 specifically includes motions in limine. The Federal Rule does not. The Federal Rule had a comment amended after that Oler decision, saying, okay, everybody, we have this Rule 103, but it doesn't address what happens if you bring it in preemptively. We amended our Rule of Evidence comment to Rule 103 the year later, and deliberately didn't, I shouldn't say deliberately, but glaringly didn't do it. So for a multitude of reasons, and the last one I should add, is that there is no federal constitutional right to an appeal. You don't have to have an appeal in the United States except as a creature or creation of legislation. Pennsylvania has a right to appeal, civil and criminal, in the Constitution. And I suggest that our 103 needs to be read through that lens as well. So, Justice Doherty, I'm sorry, a terribly long answer to your question.
I got it.
But that's why 103, I suggest,
Counsel,
supports us.
Can I just, this isn't even follow-up. I have to admit, when I saw this issue come up in our petitions for allowance of appeal, I was shocked. I mean, this has been settled law in the civil litigation context for as long as I've been practicing law, which is a fairly long time. So is there a reason why the law should be different in a criminal trial? Since the purpose of motions in limine, the beauty of them is you get to deal with the hand that's dealt you. You know what's going to happen to you when you start your trial. So is there a reason this law should be any different than it always has been in civil cases?
So the global answer is there is no reason, Justice Donahue, if I may elaborate briefly.
Please.
Number one, we don't have two sets of rules of evidence in Pennsylvania. So to do something different, assuming I'm correct in my explication of Rule 103 and its history and its purpose, we'd actually have to change the law. The Commonwealth has raised some concerns, and there are two. They said, look, you know, we're not like everybody else. We can't appeal at the end of a case. And that's certainly true. I suggest it's not enough to change it because, again, we're in a slightly different relationship. I'm supposed to be the zealous advocate. They're supposed to be the minister of justice. And if they're saying we want to use it, I should be entitled to rely on that. The second thing is it will invoke, if you will, almost a chaos theory if we have different rules. It's not real practical, then we're going to have ineffectiveness claims. You brought it out first, or you didn't bring it out first, you should have brought it out first. One set of rules is simple and clean. And this is not, okay, the other thing they talked about is this fear of what's called invited or created error, that somehow defense lawyers are going to evilly think, you know what, I'm not sure they're going to use it, so I'm going to bring it out, and then I can appeal it too.
But counsel, isn't it fair to say that under our common law, if defense attorney were to bring out his conviction without filing a motion in limine, then he is challengeable? And then our case law says, no, you can't do that.
Absolutely.
The fact is, pursuant to 103, if it met one of the requirements, a.k.a. motion to eliminate, the error is preserved and it's appealable.
Exactly. What you're talking about is my disagreement with the Commonwealth and all the cases they cite. Not one involves a motion in limine.
I think the confusion's in the way the question is posed, because the red herring is the 10 years, which brings us to another rule of evidence that you cannot use convictions over 10 years, as opposed to a motion in limine being litigated, denied, and that information being introduced in the case in chief for the defense.
Yes.
Okay.
Doesn't that Rule 609 actually put a different spin on this case? Because the motion in limine here was with regard to a criminal conviction that was older than 10 years. And as I read 609, it puts the onus on the trial judge to make a balancing test on whether the conviction should be allowed in or not, based upon whether its probative value outweighs its prejudicial effect.
Justice Mundy, if I'm hearing the question correct, and I think I am, isn't this more nuanced, Mr. Epstein, because we have to wait and see how stuff plays out?
So my suggestion is that the trial judge was not in the position at the time of the initial motion in limine request to make a definitive ruling, because there was no evidence at that time to make a balancing test, so it was incumbent on the defense counsel before he threw the question out to just say, hey, can we approach the bench? Can I talk about this again? Only so we can have a fair trial, but not every trial is going to be trashed because of having to ask one extra question.
Except for a couple of things here. Number one, in this particular case, Justice Mundy, this is a one-day trial, and this is the last witness. everything is already on the table. So the judge knows, what's the defendant going to do? Deny. In a case where the judge has heard this whole stream of evidence. The second is, we ask judges to do that kind of balancing, not merely under Rule 609, but in issue after issue every day. Rule 404B, if I may, Justice Mundy, is just as nuanced and balanced. Whether something is proper lay opinion, whether something meets an exception to the subsequent remedial measure rule, we have a specified balance in Rule 609 when it is over a certain number of years. But it's the same balance judges have to do on every single other issue. And we have never said, after the judge has made a ruling, you have to ask again. If a judge said, and that's why we also frame this as a definitive ruling.
Yeah, he didn't defer ruling.
Exactly.
Which sometimes judges do. They say, I don't know enough at this point, let me defer, but he didn't here.
And were it a condition.
I'm sorry, she.
Thank you.
Counsel, can I just, procedurally as I understand this, if you are successful, you get a remand to Superior Court to address the merits of the motion in limine ruling, correct?
And that's all we're asking for.
Okay.
What did you say? I missed what you said.
I said, and that is all we are asking for, which is the right to the appeal and the right, frankly, to the appeal for every litigant in Pennsylvania who has now lost it if they, forgive this colloquial term, Justice Mundy, front the bad fact that a judge has said, this is coming in.
Right. Okay.
And
any other questions for Mr. Epstein? I think we have your case. Thank you. Let's hear from the Commonwealth.
Thank you, members of the Court.
Chief Justice Todd, may it please the Court. Joshua Gold for the Commonwealth.
Would you raise the mic a little bit? Thank you.
Your Honors, one of the striking things about this case, and something I can't quite get past, at least on this record, is the extent to which so much time and energy, and now 2 rounds of appellate briefing and argument, have been spent on an issue about the appealability of the allegedly unfair prejudicial effect of a single prior criminal policy conviction that the defense itself introduced after doing so very little at trial in an attempt to exclude it. I think that ought to be troubling, and I think that it ought to give pause to,
Commonwealth, I apologize. The defense counsel raised a motion in limine to keep a statement, the conviction out based upon remoteness. It was denied. That's called a motion in limine. What more? That is preserved pursuant to Federal Rule of Evidence 103, 1A1, whatever. What else does the defense need to do to preserve, to make this issue inappealable, whether you find it important or not?
Well, there's several things. First of all, I don't think that Rule 103 answers the question, and I think that as the U.S. Supreme Court ruled in Oler, Rule 103 doesn't address the question about preemptive disclosure. I think that's a separate question, and I don't agree with the argument that by this, and this Court adopted a rule that I think is materially similar or materially identical to materially so to Federal Rule 103. That by adopting a rule that's silent with respect to the federal comment, that materially identical language should be viewed as meaning different things. But to answer your question, Justice Doherty, about what I think what I think counsel could have done differently, I think counsel could have made an actual argument. We're talking about 3 oral sentences that were devoted, never even mind that there wasn't an argument, and I'm not even talking, never mind even a pretrial written motion in limine. Never mind even not going through the 5 Randall factors comprehensively. I mean, even the factual predicate of any argument that the conviction isn't automatically admissible under Rule 609A.
It seems, counsel, if I'm hearing you correctly, you're conflating the substantive merit of their motion in limine as against what's at issue here, which is a waiver argument. So I'm still not hearing in your response to Justice Doherty why our Pennsylvania rules should be read to force a litigant to choose. If they preserve their motion in limine, why are you entitled to dictate to them their trial strategy going forward? Why aren't they allowed to try their case within the rules of the road set by that trial judge, so long as they preserve their objection?
And I will say, I don't think I am conflating the question, and I think that what I'm going to, speaks to what ought to be considered preserving the issue such that you should be allowed to introduce evidence and then complain about it. Now, I mean, even some of the cases from other states that my friend cites talks about what happens after a fully litigated motion in limine, often with respect to an issue of law. And see, the question that you posed to my friend Justice Donoghue, I don't think there's a separate rule. Or ought to be a separate rule for civil and criminal cases, but I think that there is a distinction, I think, between issues of evidence that are more akin to issues of law, that don't turn on context, don't turn on who testifies and how they testify, and issues where I think there may be there may be more force to the argument that you really have the judge's law of the case, and I think that speaks to the concern that amici have raised, where they're concerned about what I understand to be mostly the litigation of issues of law, and I take amici's point at least to the extent of saying I think they've raised a valid concern about not enlarging this issue and not deciding issues beyond the Rule 609 issue before this court.
But if anything, here where there's a liberty interest involved, it's all the more compelling, because what you're doing is that the defendant has asserted his motion in limine, the trial judge denied it, and now at the cost of his liberty, he's forced to sit back and let himself be impeached, or not impeached. He'll let himself be appearing to be disingenuous or appearing to hide something by not bringing it out on direct. I mean, it seems like a basic, elemental point here that any lawyer in a criminal or civil case is going to want to get ahead of it if they're bound to a situation where the evidence is coming in.
I'm not sure that I agree with the premise that you're forced, but I do think that sound principles of both fairness and judicial efficiency counsel in favor of saying if we're going to relax the general rule that says you can't get relief from evidence you've introduced, that rule ought to be reserved at a minimum for cases in which the defendant has done the most they reasonably can do, as opposed to the absolute minimum to try to exclude it.
Well, counsel, let me explore that argument. What more do you contend they should have done than raise a motion to eliminate? Because having done this for 29 years in a trial court, 9 out of 10 times, the only time it happens is the defendant's called and then the prosecution seeks to cross-examine him without getting an advisory opinion on the issue before the judge. What do you contend they should have done in addition to raising a motion to eliminate or a pre-offer determination?
I think you could actually attempt to develop the argument that you're going to fault the lower court for not addressing in the first instance. My friend argued below that notwithstanding the lack of really any reasoned argument on the subject, that the lower court erred and abused its discretion irreversibly by not spontaneously going through and comprehensively analyzing the 5 Randall factors. Moreover, I think that at least part of the presentation— But
isn't that what he's trying to do on appeal to the Superior Court? I mean, all we're asking for here, we're not asking to overturn a conviction. We're asking for determination that the appellate court, the Superior Court, can review that determination.
But the argument below was that the lower court failed to make that determination based on arguments that weren't made to the lower court and based even on facts that weren't proffered to the lower court.
Make? The judge can make his or her, in this case her, decision based on, whatever the judge has before her and whatever the judge's knowledge of the issue is and study of the law. Why does that impact the question that's before us? I don't understand that. I'm missing your connection.
I'm sorry, Chief Justice Todd?
You don't understand my question.
I'm not sure.
If I can,
Can I try to, can I try another shot at that? The argument that you're making to us right now seems to me is the argument that you should be making to the Superior Court on remand when they are asked to decide whether or not the trial court erred in its ruling on the motion in limine.
My interpreter.
And your argument would be they didn't frame the issue. Here's how they framed the issue. Based upon this framing of the issue, the trial court did not err, period. Superior Court says, I agree, affirmed, end of discussion. But you're suggesting that there's some magic formula to what a motion in limine should look like, and I mean, you're essentially attempting to really rewrite what this rule says. I think this is really intended to be a pretty simple procedure. Here's how you preserve an issue for appeal in this Commonwealth. You file a motion in limine, you get a ruling on the record. Once that's done, you're protected.
Well, I think that's what his argument is my understanding is that there was no definitive ruling on the record from the trial judge at the time of trial when he kind of, sort of raised the motion in limine.
Well, and I think that's right, and I think that also goes.
Right. When the judge said, "All right, it's admissible, it will be allowed," that sounds like a ruling to me.
Well, but I think the question isn't that. The question of, and I think if you look at even section, I believe it's 52 of the McCormick Treatise, what is considered sufficiently definitive for purposes of Rule 103 does not necessarily answer the question about whether or not something is potentially subject to revisitation by the trial court judge. And to Justice Donahue's question, I don't think this just goes to the question to an issue that ought to be before the Superior Court, because this is supposed to be an issue, of trial court discretion. And on the record that we have here, we have an argument being made that even if you raise if you make an in limine request like the one made here, that you then have a right to ask the Superior Court to reverse as some sort of structural error based on the trial court's failure to exercise the kind of discretion.
But counsel, it's not a structural error. It's an admission. It's an admission of evidence, which is an abuse of discretion standard.
Well, my friend argued below that the simple failure to tick through the 5 Randall factors and comprehensively analyze them was itself a basis for reversal.
I'm not going one way or the other. All I'm suggesting is, if you want to make that argument, why can't you make it to the Superior Court?
I think that the problem here is that if the rule about preemptive disclosure is expanded so much that even after the kind of presentation you've had below, that's considered good enough, I think that
Wasn't there a ruling? Am I wrong? Wasn't there a ruling on the motion in limine? You keep saying maybe there was a ruling. There was a ruling.
That's a ruling for 609 for Rule 609 purposes. Rule 103B's purposes, so you seem to be. Are you telling us, well, the motion is made, the ruling is made under 103B, but now, unless the lawyer goes into a rhetorical flourish and does a Clarence Darrow thing, or develops an artisanal, it's just like the most skillful argument. I don't understand. It's either yes or no. Either the motion's made and ruled on, or it's not. And correct. By telling us that it's not, that seems to be an obfuscation of what happened.
No,
and to try to go back to, well, they didn't really argue too much for the motion in limine ruling, or they didn't present adequate arguments. To me, that is irrelevant to the issue we're looking at now. A motion in limine was made and it was ruled on, right?
Respectfully, I don't agree with that framing, just because I think that the question about when the traditional rule that says you can't get relief from evidence you've yourself introduced or apply or yield, I think that is dependent, or ought to be dependent, on the record, and I don't, and that
it is dependent on the record, insofar as the motion in limine was denied. So the defendant then knew that this evidence was going to come in against him, and he decided it'd be better or his counsel decided it'd be better to bring it out rather than have it brought against him.
There'd be a PCRA probably. I don't know whether it would win or not, but if he didn't do that, there'd probably be a PCRA.
I feel like
because he didn't. When we lawyers try a case, the judge makes a ruling. We can jump up and down all we want, make arguments, but the judge's ruling is the law of that case until it's reversed on appeal. So I don't know what you wanted him to do when the judge has made a ruling. He's got to live with that. He's got to try the case as best he can, and you're telling us that he's trying the case as best he can, but he has to sit on his hands and wait for the Commonwealth to make him look like he's hiding.
No, I respectfully disagree, Justice Wecht, I think there's two things. I don't think it needs to be an artistic argument, but I think that I think that before you ask this kind of rule to yield about introducing your own evidence, I think that you ought to have done your level best to try to actually win the issue at trial, as opposed to for the first time on appeal. And the other position that is, I mean, this is even the treatises that my friend cites recognize the potential invited error issue on this record, and in criticizing the U.S. Supreme Court's older decision, say at least what you could do is you could give the option of giving the judge and
I don't mean to cut you off, but you're going on about the substantive nature of an argument. The question before this court is, did the defendant meet the necessary procedure to preserve a challenge?
And on this record and on this issue, in the view of the Commonwealth, we think the Superior Court correctly answered no. The other thing I would try to say is the consequence to, I think, the rule that my friend is advocating for is judges will be inclined to withhold rulings on motions.
Well, Counsel, that may be
advocating for a rule. This rule has been around forever.
That may be a different case. I just want to make sure I understand your position. You're here involuntarily. We took the case, so I appreciate the fact that you're here arguing. And this may be a response to what Justice Wecht is saying. Your argument is not that after the judge ruled, defense counsel had to do a few good men moment and say, but I strenuously object. You're not suggesting that. You're saying that in order not to waive, the argument on the motion in limine had to be of a certain quality to preserve. It's not just enough to make the motion and have it overruled. There was a quality of advocacy that had to happen to preserve the issue. That's how I understand your argument.
I think just in the broad sense, I think that before the general rule about not being able to complain on appeal.
Well, I don't think you should go toward the general rule thing, because I'm not sure you're convincing us that there's sort of this general rule in the context of motions in limine. There may be a general rule in terms of just jumping in and putting evidence in without a motion in limine, but just stick with my question. Where is in your view, to preserve the issue, did the advocacy is it a quality of advocacy issue in presenting the motion initially, or are you suggesting that we had to have the strenuous objection following the judge's ruling?
I think that either way, I think there would need to be a case where you would need to be able to say the lawyer really did the reasonable best they could to oppose it as opposed to the minimum. And I think with respect with.
He said, I would move to preclude that. What is the authority for us to dictate a certain quality level or detail level of advocacy on a motion in limine?
I think it's within this court's power to determine what is sufficient.
I'm going to ask you to hold on just a moment till the sirens go by. Okay.
And I would just emphasize that in addition to not developing an argument, I mean, we don't even have in the 3 sentences devoted to this. We don't even
Counsel,
have.
And again, I apologize to interrupt. Your premise, again, seems to me to. We have this principle in appellate law, which is you preserve issues, not arguments. right? It's clear they preserved, well, maybe they didn't. You're saying they never, maybe their motion in limine was inadequate to preserve the issue because they did not make a detailed argument. Is that what you're saying?
I think yes. I think on this issue and on this record, we agree with the Superior Court that it was.
Well, the Superior Court simply see that's the problem. The Superior Court didn't say that. What the Superior Court simply said was, you invited the motion in limine was ruled and you opened the door. The Superior Court didn't say, we find waiver because you didn't specifically preserve this issue on appeal in your motion in limine. You're trying to do something else. That's a different waiver ruling than the waiver ruling we're confronting here.
I'm not entirely certain that I agree that the Superior Court did or needed to draw that distinction. I think the Superior Court's holding was that that what happened below wasn't sufficient. That what happened below that you are not entitled to relief from this evidence that you yourself introduced. And and that is part of a traditional rule that doesn't necessarily have to do with in limine rulings. But and I think that on this record, and on this issue, the Superior Court's ruling was correct. And again, I take the point, of amici that I think a more difficult question would be presented, one not before us today, about where you have a fully preserved issue, especially one more akin to one of law. And to your other question, the point about even the possibility of asking the judge to revisit the question at the close of or near the close of the defendant's testimony, which also would have given counsel the opportunity to make the actual argument he didn't make before.
It had been ruled upon. It had already been ruled upon, right?
But that is true, except that Rule 609 issues are well understood, even when they are sufficiently quote unquote definitive for purposes of Rule 103. That doesn't speak to whether they're open to be revisited in a way that isn't.
So that isn't. Suggest, counsel, that you want us to issue a ruling that creates a new requirement for trial counsel to request reconsideration of any adverse limine ruling on pain of waiver, because if that, it would seem, for you to get relief or for you to win here, that would have to be the force of our ruling, because the only other way you win is for us to come up with some microanalysis that says this was not enough to make the argument. And I don't know what the principled delineation would be for that.
That was the Solicitor General's alternative position in the Oler case. If I think it's in footnote 12 of the Solicitor General's brief in the Oler case, that was one that was supported by the treatises, and it's actually one that's echoed in one of the law review articles that my friend cites as a potential reasonable compromise position that both accommodates potentially defendants' ability to decide, when to raise this themselves or let the prosecution go forward, but at the same time not put the prosecution, not force the Commonwealth to force to defend on appeal, evidence when in a way that's unfair to the Commonwealth. The choice has really been taken out of the Commonwealth's hands and to an extent out of the court's hands. And I think that.
Okay, I think I'm going to bring this to a close. We understand your positions. Did you have a final question, Justice Donahue?
I just wanted you to address, because you're really asking us to revise 103B, which concludes with the premise that once you have a ruling on the record on the motion in limine, a party need not renew an objection to preserve a claim of error for appeal. And what you are essentially arguing is you have to renew your objection. Correct? I mean, you're telling us that what should have happened at trial here is that there should have been a request for a different ruling, or what?
Well, I think the Rule 103B question is not, it does not address preemptive disclosure.
It does. See, that's what I know that you're insistent that this rule does not address preemptive disclosure, but once you get a ruling on a motion in limine, you have a right to rely on that ruling and adjust your case accordingly. You must be able to do that, or the rule doesn't make any sense.
Well, I can appreciate that this Court has the prerogative of interpreting even materially identical or similar language differently from the way the U.S. Supreme Court majority interpreted materially similar language in Federal Rule 103.
Remind me, does the Federal Rule refer specifically to motions in limine? It does not. It does not.
Because I don't believe we have motions
in limine. That is
in
what is materially different between our rule and the Federal Rule.
Although Justice Donahue, the Oler decision was expressly decided on the premise that Rule 103 governs motions in limine, even if it doesn't use the words explicitly. I mean, the Federal rules don't explicitly address the existence of motions in limine, even though everybody knows they exist and that they're regulated by the rules.
I don't think that's the proposition that we have the prerogative to agree with the 4-justice dissent there instead of the 5-justice majority. You don't quarrel with that.
I don't disagree that this Court has the prerogative to do so. Our argument is that at least on this record, the line should not be drawn in such a way that this is sufficient. I do take the point that about qualifying the Superior Court's ruling to say this, this rule may not apply to cases where you really have fully litigated motions in limine, especially with respect to issues that are more akin to issues of law, which is something that I think is not implicated by this case, and something that this Court need not, and in the view of the Commonwealth, should not decide in this case.
Okay, I think we have it. Thank you both very much. Move on, Mr. Minner. Next case.
Pearlstein et al. Commonwealth, representing Aplts, Mr. James Schilder, representing the Commonwealth, Mr. Michael Spritz.
Good afternoon. Good afternoon, Counsel. In this case, we must determine whether, for purposes of the 2013 and 2014 tax years, a taxpayer was entitled to defer gains from like-kind exchanges of real property for state personal income tax purposes, as taxpayers were permitted to do under Section 1031 of the Federal Tax Code. Please proceed.
May it please the Court, Dan Schulder, Cozen O'Connor. I have with me Heidi Schwartz and my senior colleague and longtime friend Joseph Bright.
Welcome.
Our whole team is here. I guess we're the cleanup batter here today.
You're the closing act.
What?
You're the closing act.
I'm the closing act, so hopefully
he's the closing act.
Together you are. Together you are.
This case really is not a tax case per se. It really relates to how government power is administered. Will the written words be obeyed or not? That's the key here. Boiling this down is a simple proposition. Does the department need to follow its own regulations? So let's set the table here. We have 7303A1, which states 2 points. Income shall be computed under the method of accounting on the basis of which the taxpayer regularly computes income in keeping the taxpayer's books. If the department determines that no method has been regularly used, or the method does not clearly reflect income, computation of income shall be made under a method which, in the opinion of the department, clearly reflects income. Now, you have to take this in context of where it's being applied under one of the 8 classes and categories of income, net profits. Because that's the key here, because as part of this legislative construct, when the PIT was put in place, it put up guardrails. And that's something that the department has blown past, and that's the problem here. 303A3 talks about net gains and losses derived from the sale, exchange, or the disposition of property, including real property. And here's the key point here. Determined in accordance with accepted accounting principles and practices.
What are you reading from? What
The actual statute. I'm just
the actual
the statute.
Okay.
So you set the table, because that is the key. That's the guardrail that the legislature put up when it enacted the PIT code, because that means not just GAAP, but other comprehensive basis of accounting, Aplt methods. And that's what the legislature put in place, because GAAP only is difficult to administer, costly, hurts small business. Legislature didn't want to do that. Wanted to provide, to give small business the ability to have financial statements prepared, have them adequately represent the situation at the time of them being issued, and didn't want to hurt small business. So,
both GAAP and FIT both account for.
I'm sorry?
Both GAAP and FIT both account for like-kind exchanges, do they not?
Both GAAP and
Generally accepted accounting principles and the FIT method, don't they both account for or allow for 1031 like-kind exchanges?
Yes, they do, but GAAP has been changed so that it's more restrictive now and allows for more deferral than the FIT method, federal income tax method. So if
historically, many real estate investors use the FIT method consistently throughout, correct? Because it accounts for like-kind exchanges when you're selling a property and rolling in the net gain into a new property.
That's correct, because the basis of what they're doing is at year end. So they put a method in place, the FIT method, that specifically allows for this to be determined at year end and when the tax return is prepared. And those financial statements are prepared and given to their lenders so they can manage and operate their real estate and get loans on their real estate. And if this case is upheld, that is going to be called into question.
Well, here's my question. Maybe I'm oversimplifying the matter. You have a 1031 like-kind exchange. You're basically taking all of your net gain and you're rolling into new property, correct?
Correct.
There's no cash out. In other words, if I'm the guy who sells a particular property, that money that I made on it is being invested, and ultimately 1031 is accounted for. The gains are accounted for when I sell the ultimate property, and all of the gain and then accelerated and taxable, correct?
Correct.
So if I roll over a property into another property and do a 1031 like-kind exchange, if I accept the Commonwealth's argument, where's the money coming from to pay the taxes? Because I didn't receive any money from the sale of the property, right?
That's true. You deferred the gain. You exchange one property for another.
If I deferred the gain, where theoretically is the money coming from for me to be taxed on that gain?
They're going to have to come up from out of their pocket. That was the whole point of using the FIT method and using it for their tax returns, to defer the gain to future years. 101.7 clearly contemplates that. It specifically states it.
What are you referring to now?
The regulation, 101.7.
Can we just go through the regulations here? Because you're right as to the first sentence of what the actual statute says. It seems to give a lot of latitude to the taxpayer.
Correct.
We always do it this way, then it's okay with us.
Correct.
Second sentence says, unless the department doesn't believe that that adequately reflects income.
Right. But here,
does not clearly reflect income. Right.
But again, you have to read it in context of the other provisions of acceptable accounting principles and practices, because that is using GAAP and Aplt, other types of methods, acceptable methods.
I don't disagree with you, except, and really I'm trying to work through this sort of tedious
well, that's, I'm here to boil it down.
Series of regulations, but we have regulations that essentially have the effect of law because they went through the appropriate procedure. And the legislature is fully aware of what these regulations say. Okay, so let me start with one that you spend a lot of time on, and appropriate so, which is the Code Section 101.2.
That's
okay. Which okay. Now let me follow through with me on this. 101.2 raises a presumption. Okay.
A mandatory conclusive presumption.
Well, regardless, because I don't quite get that far. Because what that entire sentence says is that a method of accounting which reflects the consistent application of generally accepted accounting principles, which I read to say GAAP.
Okay, but then,
am I correct? Okay, if it complies with GAAP in a particular trade or business in accordance, blah, 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 shall be presumed to clearly reflect income if the method is used for federal income tax purposes.
and the point here with that ruling is that it's talking about an Akboa method. So it uses
Talking about what?
Other comprehensive basis of accounting.
No, it's not. It's talking about generally accepted accounting principles. That's why I'm focusing on that language.
But here's the key. You have to read that in the context of it in a particular trade or business in accordance with prevailing conditions or practices in that trade or business. If it was just GAAP, all they'd have to say is GAAP, and they wouldn't have to include that language. That language has to mean something, and it means that it's dealing with not only GAAP, but also other comprehensive bases of accounting.
See, I don't necessarily think that's the case. You may be right, and believe me, I'm open to convincing on this. But as I'm reading 101.2, there's a presumption being raised in those situations, and this applies to things other than like-kind exchanges.
Correct.
Okay, so I mean, let's get that in place first. I mean, this was not written only to reference the deferral method under the federal tax code. So
Right, but
if you use GAAP in your industry, you get a presumption that it clearly reflects income if you also use it for federal income tax purposes. That doesn't happen here because in your industry, you don't use GAAP.
Correct.
I don't think that puts you out of court. I'm just trying to see where this presumption applies because I'm not sure the presumption applies in this case.
The presumption has to apply, or else the language after accepted accounting principles in a particular trade or business in accordance with prevailing conditions would be superfluous and wouldn't need to be there, because all you'd have to say is accordance with GAAP, period, end of story. That's the whole point, is that it's referring to GAAP, but also other comprehensive bases of accounting.
It doesn't say that. I mean, it could be poorly written. Maybe it's redundant to say in a particular trade or business in accordance with prevailing conditions or practices in that trade. Or maybe that's redundant.
But I don't think it
or
is.
Extraneous.
I don't think it is, because if it was redundant, it wouldn't be needed to be in there at all. You just have the generally accepted accounting principles.
That's right.
And it's not, and that's the whole point, is that the guardrails that were set up in the statute talk about accepted accounting principles and practices, which includes GAAP and other comprehensive bases of accounting. It uses the same type of language that is that's in the statute in here, in particular trade or business, and that's why we're saying it's got to be presumed. If you meet the requirements, and we do meet those requirements, because they were all the requirements in that provision.
Except generally accepted accounting principles.
Well, our argument is you don't have to be generally accepted accounting principles. It's in a particular trade or business, which includes the other methods of accounting, cash basis, FIT method, modified cash basis. All of those things come into play here based on those guardrails that were set up in the statute, accepted accounting principles and practices in 7301.
Okay,
which was then applied and utilized. The department took that statutory language and put it in the regulation under 101.1. So you're basically putting that guardrail in place with the regulation.
Accepted accounting principles in 101 is the extraneous language.
Say that again, I'm sorry?
Then the phrase generally accepted accounting principles in section 101 is the extraneous language. You're saying that says any regularly used accounting methodology in a given trade or business is given the presumption if it's used for federal tax
Correct.
purposes.
That's correct.
Okay, so we have to read out generally accepted accounting
You
practices.
don't read it out. You read it in conjunction with the other language in that clause to say, include not only GAAP, but also other comprehensive bases of accounting.
It doesn't say or.
No, it just says as part of in a particular trade or business. And that's the whole point. When you take the regulation, accepted accounting principles and practices, that guardrail that was set up by the legislature, and the department specifically applied that and incorporated that in Section 101.1, and then in 101.2, it lays out that point in that second sentence and includes that language in particular trade or business in accordance with prevailing conditions, which includes GAAP, but also other comprehensive bases of accounting. Has to include that, or else that language would be superfluous, and the statute under accepted accounting principles and practices would be superfluous, and all you'd have is GAAP.
Okay. Can you then just address for me Section 103.13? A gain on the disposition of properties gain on the disposition of property is recognized in the taxable year in which the amount realized from the conversion of the property into cash or other property exceeds the basis of the property. Doesn't that say that the gain is recognized in the year in which the amount realized from the conversion of the property into other property exceeds the basis of the property? Doesn't that specifically rub against the deferral methodology?
No, because you have to read that in conjunction with 101.7, which specifically says if you utilize a basis of accounting that defers gain, then you get to defer the gain. You have to read these all in conjunction with one another.
You read them in conjunction, they don't make any sense. I mean, if you read 107A.
101.7, right?
Right, 101.7A. General rule, an amount, the privilege of receiving which is taxable shall be considered as received in the year in which it is actually or constructively received, unless includable for a different year in accordance with the method of accounting of the taxpayer.
That's correct. That's what that's saying, is that there is allowed to be a deferral under 101.7.
Unless 103, which is more specific, would prevail in that circumstance, which says you realize the gain in the year in which the property exceeds the basis of the property for which the exchange was made. I mean, I'm asking you to reconcile these rules for me. Or am I – if you read 103.13 in isolation, doesn't this say that the gain has to be taken in which the value of the property exchange exceeds the basis?
Yes, but again, it gets back to the general guardrails that the legislature put in place, which was adopted by the department based on accepted accounting principles and practices. That overrides that provision in that you have to guide you by the accounting method that's utilized. You can't just do it in a vacuum. And so that's how it's reconciled, is that you've got those guardrails put in place. And they put in place when the statute was enacted, and the department specifically adopted that regulation in 101.1.
Well, 101.1, I mean, we have a disagreement on how you read that second sentence, which raises a presumption.
That's
but that's not,
101.2.
that's not, you know, a sword in the heart of your case, because all that does is does away with the presumption, period.
Right, but
if I'm right, all it does is does away with the presumption, because the first sentence, you know, allows the taxpayer a lot of latitude, as
Right.
long as the methodology clearly reflects income.
Correct. And then the second sentence says you can do this, and if these conditions are met, the FIT method is acceptable, and that includes a 1031 exchange.
Well, no, all the second sentence deals with is when you get a presumption.
Yeah, but once you meet those requirements, then the presumption is that the FIT method is a proper method of accounting, and it's a proper method to utilize. Let's talk about those criteria in that regulation. The taxpayers apply the FIT method of accounting consistently. That was in paragraphs 17, 18, 19, and 36 of the stipulation. Read together, those taxpayers maintain one set of books using the FIT method to defer gains since at least the 2007 tax year. The FIT method reflects accepted accounting principles in the taxpayer's trade or business. That's the point, is that it's not just GAAP. If it was just GAAP, that's all that would needed to be said, because everyone knows GAAP means certain things. And they put that language in there because of those general guardrails that were set up, accepted accounting principles and practices. And so when you look at that, that was paragraph 20 and 21 of the stipulation. The FIT method reflects acceptance. The next point, the department's own expert agreed that the FIT method of accounting was consistently used by taxpayers in their real estate business. And the last point, the FIT method by definition is used for federal income tax purposes. As a result, when you meet those criteria, the FIT method is allowable when that includes 1031 transaction.
Maybe you could help me out with something that I haven't yet to figure out. I'll ask your opposing counsel the same question. According to the Commonwealth Court, why doesn't the federal tax approach clearly reflect income?
Why does it? Or
yeah,
does it
why doesn't it clearly
doesn't
reflect? Yeah, well, that's obviously what their holding had to be. But I don't understand from reading their opinion why they concluded that that federal tax approach does not clearly reflect income. That's the crux of this, isn't that the issue here? I mean, the statute, I mean, the underlying statute allows the department only to disallow a certain accounting methodology if it doesn't clearly reflect income. So what the Commonwealth Court had to conclude here, and did conclude, is that that approach does not clearly reflect income. And I'm asking you if you understand why the Commonwealth Court came to that conclusion.
I think it came to that conclusion because it just simply said you can't use the federal income tax method of accounting for Pennsylvania purposes, because they said state adjustments aren't included. And state adjustments are irrelevant. GAAP doesn't have state adjustments either. The whole point is that
that doesn't answer the question regarding whether or not that methodology clearly reflects income.
Well, it has to clearly reflect income when it's used on a consistent basis from year to year and doesn't skew revenue. The whole point is you can't pick and choose to try to skew income from one year to another. If you do it on a consistent basis from year to year, which was stipulated to, and it's done in a uniform method, the method has to clearly reflect income. And the Commonwealth Court was wrong.
Can I just interrupt? Because I want to tease out what Justice Donohue's asking you, because I'm reading directly what she's talking about from their brief, which is the Department asserts that IRC Internal Revenue Code Section 1031, and this is their words, distorts income if certain conditions are met by allowing for deferral of income from like-kind exchanges to a future date, and then perhaps even indefinitely. So I think the question is this a true statement? In other words, is it possible that the appellants or the taxpayers in this particular case could never owe tax on the income tax from like-kind exchange at issue?
No, well, first of all, that's not this case. That's a different potential case. But in looking at this, when the asset is sold, the deferred income is realized and recognized. So well, it's just a simple timing difference.
It's recognized, but it's carried over to a new property. So the gain is deferred.
When the property is subsequently sold or disposed of, that's a simple timing difference. Then the gain is realized and recognized and taxed. So they just...
I guess maybe the question is better posed to your opposing counsel, so I'll wait till he gets up.
So...
Yeah,
right. Another point that has been raised, that the Commonwealth raised, which is not, I think, which is problematic, is they state that it's a rebuttable presumption, and to us, in reading 101.2, it's a mandatory conclusive presumption once those conditions are met. Another point that's, I think, important here is that the Bulletin 2006-7 clearly allowed for the deferral of income.
Well, the regulation says it's informational only. I mean, they can't estoppel themselves into a violation of the law with some informational bulletin, can they?
That's true, but they can't interpret or change a bulletin in violation of the regulation. That's the Hillcrest case.
Well, which prevails, the law or the bulletin, which is supposed to be purely informational? I mean, they created confusion, but does that change the law?
Well, it gives guidance only. It doesn't circumvent a statute, and it can't circumvent a regulation. That's Saturday Family and the Hillcrest cases. You just can't do that. And on its own volition, that's what they did. That's what they tried to do. And they basically said it's the same thing, but they took out the whole paragraph of the provision in the guidance, and then they said, it's you can't use it. So that's just clearly wrong.
But they always tell you you can't use it. They tell you can't rely on it.
Well, that's
I'm not making an argument on their behalf. I'm just telling you what it says on the face of it, which is you can't rely on it.
At the time, though, the guidance, the statute, the regulation, and the guidance all were in agreement that under accepted accounting principles and practices, those guardrails were set up. The FIT method and the deferral of gain on 1031 transactions was perfectly acceptable.
All right, are there more questions for Mr. Schulter? All right, would you like to wrap up, or have you already?
Well, one final point, which I brought and bring it home again. The case is allowed to stand, as it is. Financial statements that adequately and fairly present the financial position of the taxpayer will now be called into question, because if you let the department blow by those guardrails, lenders are going to be sitting there saying, it says it adequately represents and fairly presents the financial position, but does it? That's the problem here. And that's what that guardrail was put in place, and other methods of accounting were allowed to do this, to help small business.
Thank you. Well argued. Let's hear from Mr. Scarinci.
Madam Chief Justice, and may it please the Court, my name is Michael Scarinci. I'm a Senior Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Aplt, the Commonwealth of Pennsylvania, on this tax appeal. Up until July 2022, there was no statute, no Department of Revenue regulation, and no department information that permitted a taxpayer to defer taxes on the like-kind exchange of real property. To the contrary, the Tax Reform Code expressly provides that the like-kind exchange of real property is taxable in the year of the exchange. DOR regulations are to the same. The like-kind exchange of real property is taxable in the year of the exchange. Indeed, until this case, no one thought that a taxpayer could defer taxes on the like-kind exchange of real property under Pennsylvania law. Governor Tom Corbett, when he proposed the 2013-14 budget, did not think so. He proposed amending the Tax Reform Code to permit tax deferral of like-kind exchanges. The General Assembly did not think so. In 2015, and again in 2017, and yet again in 2021, members of the General Assembly proposed amending the Tax Reform Code so as to expressly incorporate Section 1031 of the Internal Revenue Code, which permits tax deferral of like-kind exchanges under federal law. In fact, one of the chief sponsors of that 2021 legislation noted in a memorandum that Pennsylvania law contains no provision permitting tax deferral of like-kind exchanges. And legal commentators didn't think Pennsylvania law permitted tax deferral of like-kind exchanges of real property. I highlighted one such example in my brief, a 2006 article from a publication called Real Estate Taxation. It wasn't until July 2022 that the General Assembly passed into law an amendment to the Tax Reform Code, and this is important, expressly adopting Section 1031 of the Internal Revenue Code. Even though the governor, the General Assembly, and legal commentators did not see any provision in Pennsylvania law permitting tax deferral of like-kind exchanges, appellants claim that all along there was such a provision tucked away in DOR Regulation 101.2, but Section 101.2 is no tax haven. The appellants contend that because they satisfied 3 elements of Section 101.2, they're entitled to a mandatory conclusive presumption that their method of accounting, the FIT method, clearly reflects income. So there's 2 issues there, whether this is a mandatory conclusive presumption and the issue of whether their method clearly reflects income. And this is not a mandatory conclusive presumption for several reasons.
Before you get into that, explain to me what the sentence that leads up to the conclusion regarding the presumption. It says, a method of accounting which reflects the consistent application of generally accepted accounting principles in a particular trade or business in accordance with prevailing conditions or practices in that trade or business shall be presumed to clearly reflect income if the method is also used for federal income tax purposes. Does the presumption arise if any methodology is used other than GAAP?
Yes, the presumption, I don't think we've disputed that. That's the stipulations of fact.
Explain to me how that sentence says that.
I think it is, as my friend here argued, that you have to read generally accepted accounting principles in conjunction with a particular trade or business. We haven't taken any issue with that sentence. What we've taken.
Does that make sense? I mean, I'm asking you to explain to me how that makes sense. Either they are generally accepted accounting principles or they are not.
I think it's in a particular trade or business in accordance with prevailing conditions or practices in that trade or business. I think that entire clause.
It doesn't have to be GAAP. It shouldn't refer to.
It doesn't have to be GAAP because if you look at the end of the sentence, it says if the method is used for federal income tax purposes. So, and we've never disputed that. Our dispute has been with this method, the FIT method, does not clearly reflect income.
Why doesn't it? Why doesn't the FIT method clearly reflect income?
Because under both the Tax Reform Code and DOR Regulations 101.7 and 103.13, the like-kind exchange of real property is taxable in the year of the exchange. And we see this in practice, too. Justice McCaffrey, you hinted at this in your question. A taxpayer has, by using Section 1031, the ability to have what commentators have called tax immortality. They can continue to engage in like-kind exchanges, and they will continue to defer taxes even past death. So
how's that happen?
It's considered that that they haven't achieved a gain, and I think there's after death, even their heirs are not taxed.
No realization.
It's not considered right. It's not considered realized. It's not considered a gain under federal tax law. So you could have a situation where a person never pays income taxes on a like-kind exchange. And that was certainly, I think that's an extreme example, but it proves the point here that in practice this distorts income, and under Pennsylvania law, a like-kind exchange of real property is taxable in the year of the exchange.
Counsel, 101.7 doesn't actually support the position that you're taking, because the last phrase says, unless includable for a different year in accordance with the method of accounting of the taxpayer, which would anticipate using the deferral method. I mean, the first sentence in isolation might support what you're saying, but when you look at the second part of the sentence, it gets you back to what is the taxpayer using in the course of its business.
I think you do have to read that DOR regulation in conjunction also with 103.13 and then also with the Tax Reform Code that lists specifically the disposition of real property as taxable in the year of the exchange.
What are you referring to specifically?
Well, 7301
Pardon me?
7301, 7303. I think those all have to be read in conjunction with 103.13 and 101.7, that an exchange of property is considered taxable in the year of the exchange. Your Honor, getting back to the
walk me through it. Talk me through 103.13. Why does that support your position? I mean, because frankly, it's the only regulation that I've read that seems to have anything to do with the position that you're taking here. But
right. A gain on the disposition of property is recognized in the taxable year in which the amount realized from the conversion of property into cash or other property exceeds the adjusted basis of the property. It's right in there in the text. It's recognized in the taxable year, and we see in the instances where the General Assembly wants to adopt federal tax policy, it does so expressly. I mentioned 3 examples.
But that's a different issue. I mean, we're dealing with specific regulations here, which is what this whole case seems to rely on. And I'm just looking for the authority for the position that the federal method does not accurately reflect income. And you're telling me, look at 103.1.
Exactly, yes. And look at that.
Because they say it doesn't.
Yes, look at 103.13, and then look how it operates in practice, as I mentioned just a few moments ago, that it does distort income because it's the potential for never having it recognized under state law. And I do think it is important, Justice Donahue, that the General Assembly has not expressly incorporated this particular provision until July 2022. I think, as you've said many times, we have to listen not only to what the statute says, but what it does not say. And when Pennsylvania wants to incorporate a particular federal tax policy, it does so expressly. And it did just that here with respect to Section 1031. If you look at 7303A.5, the General Assembly said Section 1031 will apply it. And the General Assembly has done that in several other instances. I pointed to 3 such examples in my brief at page 23. And I'd like to just address for a moment this idea about a mandatory conclusive presumption regarding 101.2.
Before you move on to that, speaking of what the statute doesn't say, the statute does not say that the methodology has to clearly report income at the time of the like-kind exchange. You're reading that into it. I mean, ultimately, the methodology will clearly reflect income in the event that the exchange property is sold.
But not in that.
Sold for more than the basis in the property, and then the income would be recognized.
But not in the taxable year, Your Honor.
And it. Where does it say that it has to clearly
103.3
has to clearly reflect income in the taxable year? I mean, the tax code doesn't say that. I mean, Pennsylvania tax code doesn't say that.
Well, I point again to 103.13 that says it's taxable in the year of the. Let me just get to there for one second.
Yeah, I see it. That's really
recognized in the taxable year.
This is the regulation that's the heart of your argument, is it not?
Yes.
This is the only place that actually says what you're basing your argument on, is that you have to recognize the gain in the year in which the exchange takes place.
I think that's the heart of our argument. Yes, Your Honor.
Counselor, can I ask a question?
Yes.
I'm kind of a commonsensical guy, right? Specifically, when these amendments were made to the tax code, we recognized that 1031, which basically allows for deferral of gain, was going to continue to operate in Pennsylvania, right? I mean, the bulletin recognizes the 1031 exchange. So for all of these years, here's what I can't put my eyes or arms around. This is what I ask counsel.
Yeah.
If I'm a real estate investor, a small real estate investor buying and selling properties, and I buy a property at Row House in Philadelphia for $100,000, I fix the property up, I sell it for $250,000, I got a $150,000 gain right there. If I roll that $150,000 gain into a $265,000 row house with the idea that I'm going to fix it up, where am I supposed to get the money to pay the gain on the $150,000 that I've rolled over into another property under 1031, which is allowable and contemplated by both the Pennsylvania and the federal income tax? Where am I supposed to get that money to pay the capital gain in the year of the transfer?
Well, I think that's one of the problems you run into with the fact that Pennsylvania law does not permit 1031 exchanges.
But it does now, the 2022.
Yes, now.
And even in these amendments we're talking about, it contemplated 1031 because it referenced it.
Yeah, so what would happen, I think, is once the property is ultimately sold somewhere down the line, if it is ultimately sold, then the taxes would be taken out at that moment.
Correct, but that's not your argument. Your argument
That's not my argument. You're asking how would it work in common sense. That's not.
Sure, but I'm asking you, practically speaking, where would the money come from to pay the tax of the capital gains on a piece of property that I didn't get a cent from? Because your argument seems to imply that I have to basically pay whatever the rate was, 10, 15% on capital gains, in the year I transferred the property. And under 1031, I don't receive any money. The money's rolled over.
Well, you're saying, I think I understand. So you're saying under federal law you have a tax deferral, you're not paying the taxes.
Correct.
Where are you getting?
Under Pennsylvania law, according to your interpretation,
Yes, I understand.
I've got to pay gains on money that I never received.
Well, it's a legal fiction in the sense, but practically speaking, they'd have to come up.
It's not a legal fiction to the person that's got to write a check.
Right, but practically speaking, they would have to come up with the money somewhere else. And just here, we're not talking about, mom and pop shop. We're talking about very sophisticated investors that, had $1 million in tax liability for a very large sale of property.
But theoretically, it applies to mom and pop.
Theoretically, yes. They would have to come up with the money to somewhere else.
So in essence, this law is only to benefit the rich and not the average?
I think, in general, yes, I think that's right, Your Honor.
So we give more tax credits to people who have lots of money, they pay no taxes, and the individual trying to make ends meet has to pay taxes, and the government endorses that.
Well, up until 2022, Pennsylvania law did not recognize, as I said, these type of like-kind exchanges. If I could address that mandatory conclusive presumption issue, this is not a mandatory conclusive presumption for three reasons. First, a mandatory conclusive presumption is the exception. The rule is a rebuttable presumption. Second, this does not use the word conclusive. And third, a mandatory conclusive presumption would cause absurd results. And I'll just want to detail these briefly. First, as I said, it's an exception. As this court has said in cases like City of Pittsburgh versus Workers' Compensation Appeal Board, a mandatory conclusive presumption is more momentous. And I think we have to start out with that as a first principle, that a mandatory conclusive presumption is the exception. Second, the text of 101.22 does not use the word conclusive. Where DOR, where they want to make a presumption conclusive, or where the General Assembly wants a presumption to be conclusive, they use the word conclusive. For example, 61 PA Code 309.1, that's a conclusive presumption about delivery of fuel for cars or aircrafts. The regulation uses conclusive. Title 42, Section 7302, that's a conclusive presumption about arbitration, uses the word conclusive. In Title 53, Section 8844, same thing, conclusive is used. Third, their interpretation would cause absurd results, because it would result in the wholesale incorporation of the Tax Reform Code. What they're asking this court to do is incorporate Section 1031 into the Tax Reform Code using 101.2. Now, every taxpayer uses the federal income tax method, at least for purposes of filing their tax returns. So you'll see other taxpayers come back to this court and say, we use a particular provision for federal income tax method. You should incorporate it into the Tax Reform Code via 101.2. This would be contrary to principles of federalism and to the intent of the legislature. Because
what do you say this? What does it mean then? What kind of presumption is this?
It's rebuttable, Your Honor. It's rebuttable, and
by what?
It's rebutted
by 103.
By 103.13.
So why say this at all? I mean, you have one regulation that says if you do it the way they do it, it's presumed to be okay. It accurately reflects income.
Sure. But
and then what? But then you say, aha, but look at 103. That says it doesn't. I just don't understand I don't understand the rationale for the two of these.
Well, Your Honor, we're talking about a regulation that applies more broadly than just in this one situation. So federal income tax method is going to clearly reflect income in many situations for purposes of Pennsylvania law. Again, page 23 of my brief, I mentioned several, including one we're probably all familiar with. When you sell your primary residence, both Pennsylvania law and federal law do not consider that a gain or income. That's an instance where Pennsylvania law, federal law coincide. The federal income tax method would clearly reflect income. But when we're talking about this specific instance of a like-kind exchange of real property, that does not clearly reflect income for purposes of Pennsylvania law. And just to finish my thought before about the absurd results that would follow from the wholesale incorporation of the tax reform, the Internal Revenue Code, as I was saying, Pennsylvania has the right as a separate sovereign to determine its own tax policy. And as I mentioned earlier, also when the General Assembly wants to incorporate a provision of federal income tax policy, it does so expressly. Your Honor, I think I can wrap up here. I think you understand my argument. I'm happy to answer any further questions if you'd like.
Nope, I think we've got it.
Thank you, Your Honor.
Thank you.
Thank you both. Very, very good presentations. I don't think it would surprise counsel to know that Justice Donohue's favorite class in law school was tax. All righty, this concludes our Philadelphia Spring Argument session. I'd like to thank PCN for providing the educational videos to the public of our sessions. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, for their service to the court, as well as our court security, Gary Shovlin and John Evans, as well as the Philadelphia Police and Special Dignitaries Unit. We appreciate your service. And Mr. Minner, you may adjourn the court.
Thank you. Thanks, Brian.
This is the latest I think we've ever sat.
No, we sat with administrative section like to after 5.
I'd like to thank the voters of Pennsylvania for putting me up here.
Is that right?
Okay, no going back now. Hey, watch it there.